Anticipated bail application we have filed Tuesday on. Anticipated bail application we have filed on Tuesday. It got registered, not listed. Tomorrow, madam.
May I please?
Tomorrow or Monday?
Tomorrow is the tomorrow.
Or Friday?
We file it on Tuesday, madam.
I'll rise early. Already 54 minutes.
Some accommodation.
So accommodation I can keep. Suppose I grant you bail and I could not sign it. I'll have to leave work tomorrow for some other work. That's why I asked her not to keep many minutes. Already 54 feet. Anyway, we'll take a chance.
Obligation.
Okay. May I please? In item number 34, I have filed an objection. My affidavit may be called for. That's it.
Yeah, please, Lordship. In item number 42, we have filed a written objection to the Lordship. That may be called on record.
In item number 42, the informant has filed an objection. The counsel for the informant has communicated that they have filed an objection and yet to receive the copy of the same. So, my lord, matter may be taken up next week, man.
We take up next week. Let it come. Taken up. She made a mention. Let it come. We'll adjourn it.
May I please, Lordship? I beg to mention listing a AB for withdrawal.
Please, your Lordship. Item number 11, AB 3490. Engaged senior counsel will be arriving from Kolkata on 16th October. So matter may be fixed on 16th October.
Give the file. Okay, I can.
Wait, please, Mr. Lordship. Lordship, I beg to mention item 50 of the daily list and the matter can be adjourned. We need to file in item 50 of the daily list, sir.
What?
Lordship, we need to file an additional affidavit. The informant and the accused has already performed their marriage. So the marriage certificate is to be brought on record.
I think that is there already. Okay, we thought of allowing this petition. Yes, adjourn on the prayer after vacation.
Highly obliged.
Ma'am, your Lordship, I beg to mention item number 24.
Yes.
Did he not receive Lordship?
Any interim?
Interim is there, Lordship,
What about 23? What about 23?
23 Belega.
Is there an interim 23?
Yes.
23 also.
Total.
We wait for some time. 23, 24 not.
Okay, let's
Please, Lordship, I beg to mention item number 25, madam. In this matter also, my CD is not available. And interim order is
What is the offense? Maybe interim is there.
Yes,
When?
on 16/11. Obliged.
May I please, Lordship, yesterday I have filed AB is AB number 10839.
There is a standing order. If it is beyond 7 years, all are allowed.
Yes, Lordship, it is more than 7 years. So it is urgency.
Allowed, all allowed. We'll try our level with. If humanly possible, we'll do. If not,
Please, Lordship, I beg to mention item 34. CD is not available.
Item number?
we already made a mention.
30.
Objection was
Okay,
supposed to
let
be
the
filed.
objection come. We'll adjourn it. CD is not here.
CD is not there.
Okay, we'll
Let the matter be. It's
May I please? This is 439 bail application and he is in custody for 33 days.
forget about the custody. Who was the affair?
Lordship, kindly see page 1.
Yes, let us first take Mr. Chaudhury's case.
Page 10, my lord, is the affair.
Just a minute. Just a minute. Mr. Chaudhary, we have dictated the judgment. We're supposed to deliver it.
My lord.
But problem is that the facts you have lost without insisting too much. A word you have submitted, it might be a minor,
One of the
one of them. If we go by his 330 statement, he will be a minor.
Right.
Now you will have to assist us what to do.
my lord, that has to be inquired by them.
I'll have to inquire, but what act will we do? Because this happened in 1994.
Right.
Now act in force was 1987. And so you'll have to just address us whether what was the provision in the 1987 Act and whether we'll have to follow the procedure under 1987 Act
Or the new act.
or the 2005 Act
Right.
or the new Act. That much when
Yeah. Monday, my lord.
Monday. This matter was heard on 29/20/23. Hearing was concluded in this matter. Hearing was concluded on 29/20/23, and judgment. While dictating the judgment, this court noticed that accused number three,
318, my lord.
three, Philo, while going through the 313 statement of the accused number three, it was seen that the accused number three,
Ritu Bora.
Ritu Bora, might be a minor on the date of the
Okay.
commission of the offense. Accordingly, this matter is listed under the heading to be spoken to. Mr. Chaudhary, learned counsel, submits that he will address the court on that issue on Monday next. Accordingly, please this matter on Monday. Issue is whether in 1987
Act will be, my
Act
lord,
will be
or
applicable,
not.
if applicable, and what was the age at that point of time. And if it is, I could not do the
My
research.
lord,
If it is applicable, then what is the procedure? We'll call it.
my lord. Yeah, I'm obliged.
My lord, phase 10 is the my lord, affair, my lord, against the petitioner, my lord.
Misappropriation of money of job card holders.
To the satisfaction of
My lord, CGM.
CGM we know, but which CGM?
Zubri,
That is also you are not ready.
Bilasi Pralot.
SDGM, blessing.
SDGM,
Developed.
which funding? Considering period.
Please, your lordship.
Yes,
Your lordship, the FIR is at case number 14, your lordship. Earlier, your lordship,
rejected.
AB
AB
was
rejected. Now you surrender.
Yes, your lordship.
Okay, let him go. To the satisfaction of
Special minister.
CGM Kamrup Metro.
CGM.
Oblige, your lordship.
Wait. 439 application matter, he has arrested on 24.
Nature of allegation and period of detention. To the satisfaction of
Action by the judicial. Judicial, it is for Carbiang, SDGM matter. Carbiang no matter, yes, madam.
SDGM.
SDGM. These are the 439 matter. He has arrested on his tank,
scan copy. Of
matter.
scan copies of
Can copy of the, it is from Baksha matter. The
I
judicial
know it
matter.
is from Doctor. Scan copies of
KRC case number 899.
okay, that also we will do.
Yes, madam.
I know.
Yes, no, yes.
We'll do that.
Yes, yes.
That is our job. Yes, next case.
Wait, please, your lordship. Lordship, I have been languishing there in 158 days. And the
Scan copy.
Yes, okay.
158 days has been in languishing there.
Do you want a day bail on day one without going to her statement
Lordship,
and all?
this is the allegation is 376 and 511. No ingredient is available in this.
Where do you, from where do you get it? That no indicator. So, can copy. Of
Session case number 127 of the 2023 and pending before the district and session just moving on.
given it.
The FIR is at page 8.
Recovered.
Yes, Lordship, and yes, made a statement also.
Where is your recovery statement of recovery? That sister-in-law paid with the brother.
Yes, sir.
The problem is that sister-in-law is too young,
Yes.
and
but
there is
this
a
he has been
proposal of
recovered.
marriage.
Lordship, actually her age is 19, but otherwise they would have registered the case under POCSO.
Now
It is not-
you are happily living both the sisters.
No, she is in the paternal house.
You
But
have
this he has been
an
recovered, doctor.
you have an instruction
Lordship.
whether it is recovered.
Yes.
If recovered, we'll allow it.
Yes, she's already recovered.
Where is your statement?
Yes.
Let us have a satisfaction from the
Let-
people.
Lordship.
Wait for something. Yes.
Petitioner is behind the person for last 80 days.
So forget about that.
Not the name accused well in the petition. FIR. FIR special. Money was already recovered. Madam.
The informant, he said to the informant,
Not-
that give your 7 lakhs rupees,
Yes.
give your 1,95,000, I will give you 7 lakhs. And this idiot has given
1 lakh.
1,95,000, taken 7 lakhs, and all 7 lakhs are fake.
Yes.
To the satisfaction of
CGM commitment.
Deep loaded.
CD. When?
On 1910.
90,
Along with the PM report.
12 PM.
Application Lordship. Protection and available petitioner is 16 days behind the bar Lordship. FIR page number 10 Lordship. Activity is at page number 14.
Why he is being implicated?
Not
Lordship, kindly give us a date what to produce the case.
No, but nothing is there against.
No.
Even in the forwarding report.
Not.
Why should he be behind? Considering the fact that the petitioner is not named in the FIR, as well as nothing is discernible from the forwarding report. And also the fact remains that nothing is recovered from the present accused and he has been arrested only on the suspicion which is reflected from the forwarding report. Considering the above and also considering the period of detention allowed. When?
Lordship.
To the satisfaction of?
CGM not looking for.
Yes.
Not okay.
It is a Lordship. My Lord, FIR is at page 10. My Lord.
Are recovered?
Yes, my Lord. It is mentioned in page number 17. First line.
He has been recovered from the possession of the.
How many days?
Date of forwarding is
18 days.
2509.
To the satisfaction of?
JMFC Bukum. Keep that.
CD. When?
Lordship on 1910.
FIR page number 10.
Recovered?
Recovered.
Yes, madam, have the instruction.
Lordship.
We'll have it after. Yes,
Council is absent.
none appears to the prisoner. God list of the. We'll take it up after some time because there will be a fight.
No, I should get one copy, man. I'm not getting one copy of. I request, my junior requested Mr. Ali, but he said, no, why we should give a copy? I think I should do that. It hardly matters a difference, man. If they doesn't give a copy, it's okay, fine,
my
my
lord,
lord. I FIR my only basis of FIR.
Copy is not an issue. Only question is, I think the FIR is lodged by them only.
Yes, it's okay. I'll no need, my lord.
No, no,
Without copy.
let's see, Mr. Chaudhuri, we'll decide this method. That was our idea. That's why we fixed on Thursday. You have a go through it, we'll take up at 2.
Really, okay.
Okay. Otherwise, you'll have to stay, notice, stay, or something like that, or to reject the stay. Why should we do all these exercises? We'll decide. Either it will go or it will survive. That's all.
2 o'clock, little later, there is a special bench today. A little later, at 2 o'clock only.
Okay, or can it be on Monday?
Monday, they will leave it.
No, my lord, let
Monday,
me say today.
Okay, we'll
Little
take
later.
as per your convenience.
Yes, yes. We'll just take about 15 minutes.
Yes, yes.
Special bench is there.
No problem, no problem. We have many methods. Yes, Mr. Bora,
My lord.
enlighten us.
Well, first of all, I like to draw lordship attention to the POCSO Act. My lord.
Just think that I know nothing.
Yes, my lord. Because the allegation is that, that we read out the FIR in our bar,
Hmm.
and accordingly, in the FIR discloses the name of the victim.
Hmm.
That is the allegation. So this section 23
Hmm.
has been charged against us. Now the section 23,
Hmm.
the no person shall make any report
Hmm.
or present comments on any child from any form of media or studio or photograph facility without having complete and authentic information. That's it. So as we have read the
Okay,
FIR,
okay, okay.
so
okay.
that part
Section-
is gone.
gone.
Now, second part is now the 228A, my lord, IPC.
IPC. IPC.
So now what happened, my lord? As the FIR was lost by the respondent, my lord,
Hmm. 220.
228A,
Capital A.
capital A. So FIR was lost by the father of the victim, and as the accused,
Hmm.
he happens to be the
Lawyer.
lawyer.
Hmm.
So the father made a request to the bar to take action against him, appropriate action against him, and he also requested not to accept the case against in favor of him. That was his. So accordingly, on the basis of his petition, bar has taken the resolution, and the resolution, this has happened. So subsequently, 228, my lord, the proviso is important, my lord. Proviso 2, proviso subsection 2, explanation.
Hmm.
Two C first, my lord. Where the victim is dead or minor or unsound mind,
Wait.
2C, my lord. 228, 2C. Two is nothing in subsection 1 extend to any printing, publication of the name or any matter which may make known the identity of the victim if such printing and publication is.
Okay, heard Mr. A.M. Bora, learned counsel for the petitioner. Also heard Madam Bora. Present application is filed under section 482 of the Code of Criminal Procedure, 1973, seeking quashing of the proceeding in special POCSO case number 54/2023, pending in the Court of Learned Special Judge Nagaon. In special case number 54 of 2020. The further challenge is an order dated 16/8/2023, passed by the Learned Special Judge Nagaon taking cognizance of the offences under section 228A IPC, read with section 23 of the POCSO Act against the petitioner. The background fact of the case is that the petitioners are lawyer by profession, and they are the office bearers of Nagaon Bar Association. Full stop. While taking an action against one fellow advocate against whom a case under POCSO was pending, was expelled from the membership of the association, and while having a press conference, they read out the FIR. Full stop. On the basis of while reading out the FIR, obviously the name of the victim under the POCSO Act, who has in the meantime expired, was also disclosed. On the basis of such press conference, aforesaid prosecution was initiated against the in the considered view of the court, prima facie, in the given facts of the present case, section 23 shall not be applicable so far relating to the present case. Coming to the section 228A of the IPC, subclause C of section 2 provides that the section 220A shall not be applicable when the victim is dead, amongst other, when the victim is dead. Consider it the aforesaid, this court is of the view that this matter needs further consideration, and the petitioners have been able to make out a prima facie case for quashing of the order dated
16/8,
16/8
2020.
to 2023, whereby the cognizance under section 228A IPC and section 23 of the POCSO Act was taken against the present petitioner. Accordingly, considering the matter in entirety, the impugned order dated 16/8/2023 shall remain suspended. However, it is made clear that other accused is there.
No, man.
Only you are only that
Three
other.
accused. No, only 3 accused, because I was the president, my lord, and the 2 others.
No, what happened to that original case, which was a POCSO against that?
So that is pending, my lord.
I thought that in that case you were roped in.
No.
It is
It is
independent.
an independent case.
So in view of the further proceeding of the, instead of the order, in view of that further proceeding of the special POCSO case number 54 of 2023 pending in the court of learned special judge Nagaon shall remain
So
suspended.
only one line, my lord, regarding 228 2C explanation, my lord.
Explanation. 22
That on
C.
explanation. Obliged. Respondent
Authorized
is
presence is not necessary.
obliged.
Yeah, I tell of.
May please, your lord. For 38 application, my lord. The FIR is at page 13, my lord.
City interim within 10 days.
Date is 22/11, Lord.
Wait, with the law.
Yes,
Well, 34 days, my lord.
Lordship,
I'm
here,
a government servant, my lord.
injury report is there.
may I submit, Lordship, your search sheet has been filed.
No, RCT has been filed. That does not take
Then
away
we,
lordship's
then
power.
we can call for the
Call
scan
for the
copies.
scan copy
Yes.
of else.
You be sometime there. Otherwise, you'll have to go there because we want to see the CD is not here.
CD is
No,
not
my lord,
there.
what I'm saying is, I'm a government servant. There are certain allegations. That allegations will be taken follow at the time of trial.
There is no issue on that.
Ah.
You-
Why, my lord, if this charge sheet has been filed, then my custodial interrogation is not necessary. There's already
No,
more
no,
evidence.
custodial question of not custodial. What my limited understanding is, what I think is that moment search sheet is filed, your indefeasible right is, or our power is a little bit different. So what I propose is, if we can have the scan copies
Yes.
of the case diary
Yes.
or the proceeding, that should be a better proposition for us
My lord.
to do or to allow it. Otherwise, what we do is we send you back to the
Trial court.
trial court. You have an argument and come back to us.
Oh, my lord, once
search
search
sheet
sheet
is
is filed,
filed.
there is some change in the scenario.
Scenario. So without having that, if otherwise, if city would have been there, I could have taken, because this is my concept. What
That's
is the
correct.
necessary?
That's correct.
Until and unless there is grave threat that you can. So that portion just we have to see,
On Monday, my
but will it come? That will have to
Registry
fall
notes,
by
yeah.
the registry. That is, so you have two options. Either you approach the sessions court on Monday itself. Why I'm saying is, it will
No, my
come.
lord, my learned friend says if the requisition goes, the record will come by Monday.
This requisition is go from our registry.
Registry. I
Registry.
think my junior can take some initiative. Let us try,
If
my
you
lord,
can,
on
we'll
Monday.
try. Okay. It is submitted that search sheet has already been filed. Search sheet has already been filed. Accordingly, for consideration of this bail, this court will require to peruse the
Scan copy of
scan
LC
copies of the proceeding before the proceeding
along with the CD.
along with the CD, which is pending
Pending
before
before Lordship, Special Judge, Sibsagar Lordship.
special judge Sibsagar. Accordingly, the scan copies of the Sibsagar, scan copies of the CD along with the CD in give the case number.
Yes.
Yes, sir.
Scan
36,
copies, scan
Nazira Police Station, case number 36 of 23.
23 under section 324, 342,
And
307,
326,
326, 506
Six.
IPC. We call be requisition. Let it be on Tuesday. Let us be in a safer place.
Okay.
Yes.
Tuesday.
17.
Deep look.
May I please your lordship, item 16 and 17 may be passed over for the time.
Why? What is this?
Lordship, this is a matter of 2015, Your Lordship. Your Lordship, the petitioner was earlier on bail, Your Lordship. Thereafter, Your Lordship, it is accused that he has jumped his bail, Your Lordship. Your Lordship, I have not received any summon, no warrant, Your Lordship. In the meantime,
Why to bail application 34433516?
Your Lordship, both the persons are different person, but
Different person.
but same
Scan copy.
same
Scan
case.
copy was called for
Okay.
Lordship. We have to go through it.
Please go through it. After something.
Lordship.
Yes,
Lordship, in this matter, city was called for,
you have called for. But-
along with the medical report, Lordship, because 307
In this case, we have not received the medical report. The person is on interim. But let the medical report will come along with the one
Not,
accurate
not,
case.
not, not
Not
received. Okay, the medical report called for is not received. So accordingly, matters stands adjourned for production of the medical report.
Let it come on
Please,
10th of 11. 10th, 11.
10, 11.
deeply obliged.
तुम्ही काही पाठवतो तर matter for time. Senior counsel is on like.
City is there.
19 case there is.
Where is the FIR?
Page 12.
How many days you are inside, behind?
More than 60 days.
Madam, 64 days lordship, madam, postmortem report received lordship, but the FSL report not received. Because the victim he committed suicide lordship.
Ah.
That is why, my lord, that postmortem report is not final lordship, because the visa and all this, it was sent for FSL. Because it may be a case of poison also lordship, because
Hanging.
hanging. Today is 64 days lordship, so this is the husband lordship. 64 days.
Do you require his,
My lord.
as per the city to further require his custodial interrogation?
Otherwise, lordship, he has
FSL
been
report?
interrogated lordship,
Huh?
my lord. Only if it is pending for the FSL report. Lordship.
That's
Other
why I'm saying.
witnesses are examined. Lordship.
Investigation is almost
My lord,
complete.
my lord, investigation is, my lord, not complete, lordship, but my lord, sufficiently progressed. Lordship.
Where is the case there? What is your name?
Lordship, HR.
HR Hart. Peruse the case diary recorded. Also the postmortem report. The allegation is of suspected murder. But the postmortem report is not conclusive and the FSL report conclusive whether it is a suicide or a case of murder in as much as the investigating officer is awaiting the FSL report. Otherwise, from the perusal of the case that it is seen that the investigation is at advanced stage. Statements of the witnesses has already been recorded. Statement of the accused has also been recorded. Considering the matter in entirety, the court is of the view that no further custodial intervention shall be required in this case. Accordingly, the present bail application is allowed to the satisfaction of Huh?
Cesium Hussain, lordship.
cesium. Yes.
My lord, husband and wife both were in the same vehicle, my lord. The vehicle met an accident. The wife suspects that the husband tried to kill him. The husband himself was driving the vehicle. 24 days in custody, no police remand, nothing.
There was some lordship quarrel between the husband and wife, lordship. It was going on for last few days, lordship. But that, my
Otherwise, you
lord,
cannot prove that he
accident, my lord, it seems to be, my lord, is intentional, lordship, because there are some disputes going on, and the witnesses said, lordship, intentional.
is inside. By no means you can prove that it was a case of murder.
24 days, lordship.
Seriously objecting?
My lord, submission may be recorded, lordship.
Okay, submission recorded. Serious objection. To the satisfaction of
CJM Dibrugarh.
May clearly possible matter senior class Dikera is electing other court.
21 case that is not clear.
Yes, that is not received. What is the allegation?
T06 is allegation and you know 70 days he is behind the bar and alternately after already they are filing the charge sheet and in the meantime honorable court knows very well already previous bail application 3 to 9 was filed which is withdrawn with the permission of the court and lastly we are filing in the Barbata session court and that bail is rejected on the ground is there some hamper of the prosecution and you know
No, you want to say that already charge sheet has been filed?
yes okay.
Now we'll have to call for the scan copy. Scan copy has come. We have called it.
Already called it but not yet received and 30 September 2023 the consideration search was completed and tomorrow my lord the fix for evidence 13/12 in Barbara session court is there behind the bar for fair and trial participants kindly allow the bail for the petitioner.
No, that we understand, Mr. Counsel, but on what basis will allow?
Already we received all
Because when search sheet is filed,
yes,
the situation changes.
kindly 2 minutes my lord my senior is selecting other court.
No, that we understand.
Yes, sir.
But here was a judicial order calling for the scan copy.
Yes.
An office note said has not been received.
Yes.
So we are issuing a reminder.
And my lord,
Be issued, lord.
Charge file all the copies necessary document received by the accused petitioner, and tomorrow is the date for evidence.
So why have you not enacted all those things?
We got, but I have
So
but
you would, if you are so serious,
Yes.
you would have filed an affidavit bringing all the
all the
161 statement.
yesterday we have received the copy from the certificate copy
The
from
file
the
it, we'll see, we'll fixing it on 18th.
and 1/6 I understand everything, but 6 for
If
baby.
you understand everything, where you are going?
So my prayer is it's so simple, my lord. The 6 years baby, he's behind the bar more than 7 years.
Scan copy come notice 30 case notice otherwise.
That is, we do not understand. We know the lawyers are having pressure.
Yes.
But we'll have to do justice.
Yes.
Is not it?
Yes.
Can I pass and allow you bail without looking into anything in the air? There is a charge sheet file. If you are so serious, you ought to have brought on record everything.
Tomorrow, can it may allow me they are sick for another day, so I'll file the indemnity paper along with the copy. I've received, yes, sir.
The learned counsel for the petitioner submits that the scan copy call for has not been received. Registry to issue reminder forthwith in as much as the present application involved a determination regarding liberty of a person. Full stop. In the meantime, the petitioner is permitted to bring on record the 161 statement of the witnesses which has been furnished to him during the course of trial. Please this matter on 18th. Be reasonable.
Yes.
Don't come on pressure. Be reasonable. Yes.
49 days in custody, my lord.
Yes.
There was some assault, my lord.
Some assault is difficult. What kind of assault?
No, my lord, they say, my lord, in FIR that they have assault because, my lord, he was a lab technician and, my lord, he had done some indecent act with my lord, would be wife, my lord. And that's how he got agitated, my lord, and there was there are exaggeration, my lord, as usual in all FIR. No police remand, nothing is sought. He is in judicial custody since last 49 days.
It is there.
Case that is not received. So notice may fix a spot date.
Okay.
You can fix it on notice
19.
17.
You have the city.
Okay.
Kindly pass the link for timing.
For time being, it is there.
Case that is not received.
He is interim.
Yes, madam.
Case that is not received.
Petitioner number 3 is in. He is on the list.
It will come
So
after
inter-
vacation. Then.
Huh?
Case that is not received.
Okay. Case diary not received. Interim to contact.
My lord, after vacation, my lord, 15/11.
15.
Madam.
Some adjournment is for.
Case that is not received.
Here is the query in interim, my lord. Perhaps diary notice.
No, there was a keep the fact.
My lord, so
And
far as
earlier 57, it was in BA.
Yeah.
And there is an interim order.
That is why what that is there's also committed lordship interim is there. I also got little bit confused because the PA interim is there.
Granted interim bail of 50,000 to perform last rites of our father with a suitable legitimate. Okay.
Okay, madam.
Father expert. Okay.
Very much.
I can understand.
Yes, there's some adjournment short for here.
My lord, perhaps the diary.
Case that is not received. Lord.
Diary
And some objections were filed, something like that. What happened? Only adjournment. Okay, case diary call for, 23 was not there, that's why.
23.
Case diary call for is not received. List this matter,
No, 811.
interim, interim order.
Plumber के दियो.
In both the cases, interim.
मतलब मतलब can be a longer date master.
No, no, 811 also.
Huh?
मतलब
811.
तरीके दियो.
You want to enjoy, he's sure that he will be rejected. So you want to enjoy
my lord.
enjoy the Diwali.
Instruction, my lord, already trial started. But I should not submit before this court, my lord. It should come on record.
Okay.
It should come on record.
Okay, third sheet file. So we'll protect them till, okay, on that is better, 811. We will protect them.
Yes,
That
my
we will go to 811.
Public. May I please, your lordship, my lord?
Yes.
So we have interim, my lord, we have appeared, my lord. The
Anything?
husband was arrested, my lord, subsequently granted bail.
Who was subsequently granted bail?
So the husband was arrested, my lord.
Husband was arrested. Where is the FIR?
FIR is paid, my lord. 12, my lord. The petitioners are the mother-in-law, sister-in-law.
498A.
302, my lord. Registered 302, my lord.
302. Here it is the husband.
Husband was granted bail, my lord.
Now who are
Now
before us?
mother-in-law,
Who is the FIR?
page 12, my lord. Before your lordship is mother-in-law, brother-in-law, and sister-in-law.
Okay. Co-parted?
They cooperated, lordship, and my lord, postmortem report, cause of death is anti-mortem hanging, lordship.
He said, my lord, came in the
That is there, lordship.
order.
Considering the postmortem
They have
report
appeared statement recorded.
as well as the fact that the petitioner had appeared before the IO after obtaining the interim order and cooperated with the investigating authority, this court is of the view that no custodial interrogation shall be required in this case.
Obliged, my lord. Tell you about
Accordingly, allowed affidavit.
May I please your lordship?
Yes,
438 application, your lordship, today is the date fixed for CD, your
No,
lordship.
27 case there is notice.
interim to continue, case there is not one. Purva,
My lord, I am sorry, my lord, in this case. No, case there is submitted, lordship.
Trustee Chairman,
By PS, by charge number 339/2023. And dated, lordship, date is not mentioned, lord.
okay, that's submitted 30. Sessions tribal,
My lord, as part of bail application, lordship, session trial.
okay. Will continue interim order till you someone receive appear.
Oblige, your lordship.
May I please,
Yes.
I'm an interim man.
They are on interim, lordship, but postmortem report is not received. I have contacted the investigating officer, lordship. He has not been able to collect the postmortem report.
Okay.
They did come after vacation.
The postmortem report is not available accordingly. The matters that adjourned for production of postmortem report. Interim order passed earlier self-continuing. Please this matter on.
2011. We'll return the case there.
Huh? None appears for the petitioner or call. CD is there.
Case there is not received.
Case diary not case diary call for it not received. Accordingly, this matter
10-11.
10-11 interim order passed earlier. Continue.
I can number 30 minutes video was called from there was a chain.
Both the cases, case there is not received.
Case diary not received. Interim to continue when?
Not 14-11.
14.
Right.
Item number 31 also included.
Huh?
Item number 31 is also an interim lordship.
Both have granted interim. Okay. 31 and 32, is not it?
31 and
30 and 31.
30 and 31.
Oh, interim.
May please your lordship.
Yes.
438 application, my lord, on the last occasion, my lord, CD was called for.
Is there not received?
Interim is there.
In-
Okay, when?
2011.
2011.
Yeah, please, the lordship. 430 application, my lord. But I am on interim, my lord, and
It is there.
is there not received?
When?
Amolpur 9/11.
9/11. Interim.
All right.
It is there.
Is there not?
It's case there is also not received. Objection is also not received.
Yes, lordship.
Objection.
Today morning I have filed
Yes.
and I have to serve a copy to him. And,
The case that he called for is not.
and my name may be shown.
Okay.
Next.
Accordingly, list this method.
15/11.
15/11. তার মধ্যে লিখিবা। Mr.
G. Somwa.
G. Somwa, the learned counsel, has submitted that he is appearing for the informant to
Public
assist
victim.
of the victim to assist the learned public prosecutor, and he has already filed an objection.
Yes.
Bail objection to the registry to verify and take the same along with the record on the next date fixed. Next date fixed. Also show the name of the learned counsel for the victim in the court list. Interim order pass earlier.
Lordship, I have been lost to call both the case that there is a cross case also. I have already made the pair in the petition. However, it is case number
Yes, Lordship.
360 and 361.
Yes, lordship. There are
It
two.
is also seen that there are another case which
Which is
has been filed by
filed by the mother of the petitioner.
Mother of
by
the
the-
informant.
mother
No, mother of the petitioner.
mother of the petitioner
Oh, yes.
being
Being Overbury PS case number 360 of 2020.
case diary of the same we also call for.
360. 360. 360 of
360 of
20.
মিলাই দিবা last ৰ interim question. Yes.
The city was called for lordship. Case there is there, you know. Yeah, question number 1 is it was surrender and honorable court has bail granted lordship is started.
Case number 1. Zahirul.
Zahidul.
What about PR, Dilbar, Saddam and Mokti?
Pieral is the father of the Zahidul, Dilbar brother, Saddam brother, and Kamala Khatun is the mother. Mokiel is the minor. He is not the petitioner.
What is the injury, Mr. Das?
Injury report is not there anymore.
That is
164 statements are received.
Huh?
302 added lordship 302.
Huh?
Section lordship added 302. Later on he died lordship in
Later on
hospital.
he died.
James. Then I have to send back the case there.
Postmortem report.
Protection lordship. In 164 statement they are named. Lordship the only mother lordship in there.
Kamala Khatun.
Kamala Khatun.
What is her role, Kamala? What is her
Family
age and
disputes
role?
lordship.
Age and role.
Poranali and the PRL is the brother informant and the PRL is the brother.
Moki is a minor.
Minor.
Okay. So now we are concerned with Kamala.
53 years.
If 53 years is not a age, then if you call 53 years is old, the person sitting behind you will be in difficulty. Do you know that? Huh? If 53 years is old, the person sitting near you will be in difficulty. If she has not participated, should not be arrested. That is my view, a lady. If she has participated, even if lady will not, because a person has died.
Komala's name, oh yes, Komala's name is there.
Yeah.
In 165.
He also participated. We'll see. It is submitted that subsequently the victim expired and accordingly section 302 has been added. In that view of the matter, Mr. Das Lanet, additional public prosecutor, praised that he may be allowed to return back the case diary and to call for the postmortem report. Prayer is allowed. Please this matter on.
It's from Kolkata. Well, before vacation, it will not be possible.
The vacation court matter on 31st day. 31st.
I'm sorry to interrupt, Your Lordship. In item 34, Your Lordship need to pick them around 15. Can it be on 20? No? That's some
20, huh?
Is there, no?
Mayor.
Yes.
Lordship, we are on interim, Lordship.
No, that we understand, but where is the affair?
Particular is page 14, Lordship. We are not the prime accused, Lordship. The husband is the prime accused of the case.
Husband is the prime accused. He had a
There
relation-
we are below.
considering that they have appeared, participated, they are not the prime accused. Husband and Bondona.
May I please, Your Lordship, for 30 application and 302 case, Lordship, though I am named in the FIR, Lordship, only the perusal of the city, my
What is your role? That is
Lordship.
Krishna Thapa.
Lordship. On Monday, Lordship, have granted bail to one for 39. Lordship.
439. No, we have refused.
Lordship?
We have refused.
No, it was granted, Lordship. I have got out.
Granted.
Initially, we also thought, Lordship.
Or these three granted.
Only the role, Lordship, what he have paid. Otherwise, no case.
Three laborers were there. They named specifically 3 persons. Whether this is there.
No, yeah.
We have rejected the AB of the president of the club.
That I am not aware of the fact, Lordship.
Is that it? Mr. MS Som.
Now, my lord, this laborer do not know everybody, but
But
they
do
say,
not know everybody, but they say 13 people
yes.
and they specifically identify 3 people.
1,
But the
3,
wife
4, 5.
name
5-6 people were not identified by in 164 statement.
150 statement. Whether
Now, 15
Krishna is there. But the
Krishna's
wife
name is
not there, but wife's name Krishna. Wife was also witness.
maybe, my lord.
And
Thing is
these are
that,
the
my lord,
member of the club.
yes, member of the club, my lord,
Yeah.
and they have taken, my lord, who are they to, my lord, settle down, my lord,
That
dispute
is
between
why, and that
what
is why you have rejected AB.
Basically, I think, Lordship, the land dispute. Basically.
Land
land
dispute,
dispute not between the.
whatsoever, land dispute, I have thoroughly gone through the case diary.
My lord, yes.
Thoroughly gone through the case. It's a land dispute between two parties.
Look.
Regarding final payment or advance paid, they started at constructing a toilet and cleaning. These laborers were there. Then the club members,
Some members came.
members,
But that lady lost the complaint with the club.
Then
They
club
of the matter.
and they started beating
Yes.
and hit this man.
And
And
then one
therefore,
person died.
maybe we have rejected so far. hitting to-
P02 case, if my part is there, no, there, I have got no case.
One person
Okay.
died, Milord. No,
Yes.
I with all respect, I submit.
This এই যে কালিতে টি সমর কিছুতে will allow give you after you are inside.
No, P02 case, there is nothing look
Yes.
good also to submit.
Yesterday, Borua was there. What was that case?
Hey.
You were there.
Jalukbari to get
Isum.
someone level.
The president of the club.
Oh yes, man.
President of the club. That same order. Dismissed.
Much obliged. Much obliged.
Was not done.
We have granted to one who is inside. Inside is
That is all right.
inside.
Yes.
Police generally.
For some
take
days
their
he has been
statement.
here. I interrogate. Thirty-eight also case there is there, Milord.
Is there here?
My lord, FIR is at page 9. This FIR, my lord, allegation, my lord, the accused number 1, my lord, I am accused number 2, my lord.
You are accused number 2.
Yes, my lord. The main allegation, my lord, the accused number 1, who had the victim had love affairs with the accused number 1. On the day of occurrence, my lord, the accused number 1 called the victim, and suddenly, my lord,
You are accused number?
I am 2, my lord, accused number 2. I was the husband of the victim, my lord. And the victim, my lord, voluntarily divorced me, my lord. And to that effect, and shown an affidavit, my lord.
Just give me a minute. I'm
Yes.
not getting anything.
Okay.
So complicated. FIR is lodged by brother of the victim.
Yes, my lord.
Okay. So accused number 1 was having a love affair with the victim.
Yes, ma'am.
And accused number 2 is the husband of the victim.
Yes, ma'am. No, my lord.
Ex-husband.
Husband, earlier husband.
Ex-husband.
Ex-husband. Yes, my lord.
Ex-husband.
Ex-husband.
Now ex-husband is before us.
Yes, ma'am.
Why ex-husband is involved?
Very bad case, Milord. In the midnight, he came along with this accused number 1, the present lover of the victim, and he called in the midnight about 2:30 a.m. to the street. The victim came, and both of them, Milord, particularly this petitioner, Milord, stepped her. Stepped her, and Milord, she had to be referred to GMC.
My lord.
Considering the material available, including the fact that the accused number 2 directly participated in the commission of the offense. This court is of the view that this is not a fit case.
She was in medical for about 5 days. GMC.
And also considering the nature of the injury, which is previous, and she was to be hospitalized for 5 days
At Guwahati Medical College Hospital.
at that Guwahati Medical College Hospital. This court is of the view that this is not a fit case where the privilege of pre-arrest bail should be granted to a party accordingly.
Obliged.
May I please?
Yes.
438 FIR.
Hmm.
FIR is on page 8. 406 is there.
Priotos committed suicide.
306.
Who are you?
Neighbor, your lord. Villager.
What is your allegation?
Allegation that we instructed him to commit suicide.
How?
I don't know.
Now, my lord, as far as it is concerned, my lord, some witnesses, though who were, my lord, interrogated, they stated, my lord, they find some, they suspect, my lord, there must be something regarding their, that is why they.
Considering the material
And
collected.
another, just 2 things I want to submit, my lord.
Yes.
And he has also written a, my lord,
Suicide note.
Suicide note, but it doesn't matter. It says
illiterate.
it is illiterate. It is also difficult to read the suicide note because he said only 2 lines, my lord. Amar Mittu Joinne, and these 3 lines were there, my lord. And here Bemar Manhu. That is these 4 lines written. This will stand for FSL, my lord.
Yeah.
And one thing may be positive for them, my lord. They have appeared before the IO.
Otherwise, there is no space. Why there? What is the reason? And by what conduct they compel them to commit
Nothing
it?
is
There
there.
must be something that they pretended me. They wanted money from me, or they said that they will. They are blackmailing me. Something must be there. There should be a proximate cause. Considering the material available on record, available in the case diary, including the statement of some of the fellow villagers. This court is of the view that no serious incriminating material are available to reject, available in the case diary. This court has also considered that the petitioner has cooperated with the investigating authority after obtaining an interim order.
Interim is not
There
there.
is no interim.
All-
After committed suicide,
Okay.
police has
Is
investigated.
cooperated with the investigating authority and got their statement recorded, and the police has also not arrested them. Considering the above present application, that you don't have any apprehension. Your statement is recorded. You will not otherwise.
Before registering the case, statement has been recorded. Thereafter, after almost 12 days. Hello,
A condition will be interim.
Forty,
Yes.
my lord, CD not received.
It is not.
Whatever her in is not taken.
Yes.
376.
Informant is my own elder sister, sister-in-law. So her
Informant is your.
own sister-in-law.
It is a difficult.
So rare
Had
case
it been others, you would have been beaten. Yes.
things as far as land dispute not.
Okay, we'll see whether it is a land dispute or a mental dispute. We'll see. It seems a mental dispute.
No,
And the false
Yes.
allegation.
When?
my lord, whether it will be available before Puja.
You decide. You decide. I don't have any
I
problem.
may allow interim.
Yes, then my lord,
Proceed.
19 or
19.
Interim protection lot.
19.
Still lot till the interim.
No, 19th will give you everything.
Yes. Much better.
You ought to have taken a standard. It's a consenting. What land dispute? Yes.
Your lordship,
Yes.
the matter may be adjourned for the time being.
Why?
So Mr. M.A. Islam is not
M.A. Islam is
not present.
series here.
It is there, my lord.
But
My lord, regarding my lord, 436 firing in the house, my lord. Like to fire in the house. And according to the my lord witness and the my lord the victim
It's a
family.
case of rejection according to you.
Um,
Here he is sinner.
Yes, my lord.
Okay, let
They'll
us
let him help. Wait, please, your lordship. Lordship,
series there.
lordship, in this case, informant has filed an affidavit, written objection. We want to respond it. Kindly, maybe 1 week may be granted. We will file our affidavit.
What is the method?
A trail, my lord, is my lord regarding if your lordship will see the FIR, my lord, page 2 of the petition, my lord.
Yes.
Page 2 of the petition, there's names, my lord. I want to refer, my lord. They are separate material, my lord. Involvement is, my lord.
Just a minute. Okay, Kudrot Ali.
Yes, my lord. Kudrat Ali, my lord, according to this, my lord, CD, my lord, Idris, Zakir, and another one, he is not before a lawsuit. They are the, my lord, main person who have assaulted, my lord.
Who assaulted?
Assaulted, they are present, my lord. Idris, my lord, Idris is the father, my lord. He has snatched away the bag of money, my lord,
Hmm.
and assaulted by one Zakir and another person that is not before your lordship. My lord.
Zakir assaulted.
Zakir is there, my lord.
Zakir 3.
Yes, 3.
Zakir assaulted.
And my lord, Idris, my lord, he is present and he snatched away the bag, my lord, of
Okay.
money.
Then
And others, my lord, that regarding 4, 5, 6,
Mokul, Amir, Mubarak,
and
Maksud, Mahaduri. They are
and
not in.
their implication is that, my lord, in the end, my lord, the victim says that, my lord, they are also present.
Okay.
And
So no
rega-
specific role.
regarding 4, 5, 6, তেওঁলোকে মোক আগভেটা কৰি ৰাখিছিলে।
4, 5,
And
6 and 7.
And regarding 8, my lord, there is no whisper.
No.
Regarding
What about 1?
1 is, my lord, one also, my lord, regarding same as, my lord, 4, 5, 6, 7. Just I like to, my lord, just one statement, then it will be clear. He is the, my lord, victim who is along with the deceased. In the last portion, some names are there.
They are part of it. They may not have inflicted,
Yes.
but they are part of
Oil power of affidavit. So
What affidavit? We are ignoring him. Who is he?
only
Whatever affidavit he has, he might have filed. If there would have been a case, we would have ignored it. No case. Will not may not even record his presence.
8, my lord, I have not signed.
Huh?
8
Eight,
regarding
8 is not there,
8.
except Mohiruddin. All this main leader is the
Kudus, my lord, Idris.
Idris, the
Idris.
Gamura.
Idris.
Specific how it is vividly described. And you all were present. Meaning there like you have a common intention.
Hmm.
And a person has died. Bad case. Very bad case.
Not aware of the problems in the case, my lord.
Huh?
Aware of the problem because they are specifically named in the FIR.
Not only that, the injured witness vividly described who actually did it. This is Idris and Zakir.
And another one, my lord, that is not before.
Not before this court, Idris and Zakir. And this other persons, Kudrat, Mokbul, Amir, Mubarak, Musidul, all cooperated, all participated. They did not have any individual role, but they have the intent.
The presence for the
Except Moharuddin. We are granting to Moharuddin, not others. Moharuddin granted Others rejected. Huh? Considering the material available on record, including the statement of the injured eyewitness. Huh? Which discloses that the petitioner number 2 and 3 mainly participated in the assault, and the petitioner number 4, 5, 6, 1, 4, 5, 6, and 7 assisted them. Assisted them along with 1, so that he comes in his future road is let the close the future road. What was his name?
One is
Anjar Hussain.
Anjar, yes.
Another person named Anjar Hussain.
He is probably sure that he will not get.
Anjar Hussain.
No,
But
Ansar
however,
Ansar has already been arrested, my lord.
Oh, arrested. Oh,
Page
okay.
25, my lord.
okay, then we will not say that. However, there is no allegation against the petitioner number 8, considering the above, the bail prayer so far relating to petitioner number 1, names of name like stands rejected. However, considering the aforesaid material, the prayer of bail in respect of petitioner number 8, namely 20 to allow to be granted bail.
Deeply obliged.
Try to do good cross examination.
Application no interim case there was purple. Basically, both the sections are bailable except 307. But there is no intention of 307 is there.
What is the injury?
Yes, injury is my lord 43.
40.
Injury is my lord sharp weapon, dangerous.
Sharp weapon, where, which part?
It's my lord below the neck.
Below the neck.
Yes, it is my lord
Who,
left cheek and
what
left
is the statement of
left
the
mandible.
injured victim?
Injured victim says, my lord, when he was coming from my lord in the street, these two persons, my lord, they have, my lord, they have got hold of him and assaulted, my lord.
What is the motive?
Motive, my lord, they said that কঁকালত প্ৰহাৰ কৰে, পাছত ডিঙিৰ ওচৰত কিবা চোকা অস্ত্ৰৰে প্ৰহাৰ কৰে, মই পৰি যাওঁ, দেউতাই মোক হস্পিটাললৈ নিয়ে.
Who inflicted the blow?
And it is
Because it's a single blow.
yes, because অৱস্থাত অজিত কটকী আৰু কৃষ্ণ কটকীয়ে বিনা কাৰণত পিছফালৰ পৰা কঁকালত প্ৰহাৰ কৰে.
And
There
what,
two are
okay, two person understand, but who did this?
who did, my lord, that is only they both that is
Who are us before?
Both brothers.
and there is also an eyewitness to the effect, my lord.
What he said?
He says that, my lord, these two persons, when he was coming, my lord, these two persons, he saw that assaulting the victim, my lord. Thereafter they fled, my lord.
And what is the medical report?
Medical report, my lord, that is dangerous weapon and sharp
And what
weapon
is the art mark?
It is, my lord, laceration with 5 centimeter long, 1.5 centimeter deep laceration, left cheek and left mandible.
But were there any document of GNRC is there or not? Because they have made in the FIL stated that lordship they have fixed to GNRC.
Might be, but see, basic
It is
question
a
is
normal
if
way.
307 is there, we see the place first, then the impact.
But that I understand, lordship, but the section
This is AB or what?
This is
AB,
AB, madam.
325, lordship, is a bailable lordship, 325. They have not uncovered lordship section 326 lot.
307 is there.
Probably, my lord, at the point of the FIR, my lord, 325, my lord, has been incorporated thereafter.
Rejected. You have a bad date.
Much obliged, your lordship, much obliged.
Considering the nature of the injury and also considering the fact that the injury was inflicted in the vital part of the body by a sharp weapon. which is corroborated by the eye. To come back again, day one,
439 it will.
day one. Much obliged.
Not 438. Petition number 3 is an interim bail, madam. FIR is my lord 11.
Lordship, petitioners are on interim bail, Lordship. CD is up to 29, 2023.
Updated.
Updated CD.
The learned additional public prosecutor submits that we will require updated case diary. Full stop. Accordingly, place for an adjournment, prayer is allowed. Release this matter
2011.
2011,
Yes.
2023. Interim order.
CDB sent back and
Case diary sent back and
resubmitted.
the updated case diary be produced on the same.
Lordship.
May please.
Yes.
Lordship, injury report was called for that it's not received.
Both sides
Otherwise,
received.
allegations are
There's a
serious. Lordship.
mutual. There's a fight between two groups with regard to a plot of land.
Inflicted injuries with sharp weapon, dow and.
We'll reject them. Also. If there is a fight between two groups, that will not give a license.
No, Lordship, I am saying, Lordship. Is there is there, Lordship?
CD is available, but the injury report is not there.
Injury report is
That will be
necessary.
required.
One injured is, I think, minor.
Yes.
No, Lordship.
Others-
Our side is
Others are
minor.
not.
They
So
assaulted
many
our
persons are injured.
Okay.
Lordship, one.
Okay, when?
Lordship, after vacation.
Lordship, if Lordship is posting after vacation, Lordship, I'm just praying for interim for this petitioner number 1, Lordship. He's
No, no.
68 years.
Anil Putin, Lordship, he is the main person.
Because Lordship is posting after vacation.
Then without injury report, let us see the statement.
Then let it be a before vacation, Lordship.
We can try it. There is
On
no
19.
problem.
Lordship,
On
19. Yes.
19, I think we'll have to.
Then 18. Lordship.
Okay, I don't have any problem.
No.
It's
Yeah.
before vacation. Everybody will want to do their cases.
Yes.
Because I am without injury.
Yes.
19.
19. Yes, Mahajan.
May I please, Lord? Interim, my lord, period, my lord. Lord, I wanted, we have received the case diary, Lord, but my lord, we'll have to call for update case diary, my lord.
Okay. Mr. Borua, learned additional copy.
Your postmortem report is not in the case diary.
Our Borua learned counsel additional public prosecutor submits that though case diary is received, however, postmortem report is
Right.
not available.
No,
in-
victim is-
Huh?
এখানে কোথাও 302 No, it
Okay.
was lateral added 302, Lord. That is
The night.
here.
Um,
the time. The postmortem report is required.
postmortem report is not available in as much as the victim died subsequently. Full stop. Full stop. Considering the above, matter stands adjourned. Case diary be returned back and the updated case diary be produced
Mhm.
on
24/11.
24/11/2023. In the meantime, interim order
Correct.
passed earlier.
Obliged, Lord. Earlier.
Should we take up the matter after some time? My senior is in court for the
Who is your senior?
eighth or.
Huh?
Mr. Eighth or.
H.
Eighth or.
Adhar. Hard. Whose name we should record? Mr. Borua,
My lord.
this is a case of acquittal on the day 1. Go to it.
Attempt for.
We are granting him bail. Go to the scan copy. Go to the petition.
My lord.
The victim, it was a case of 307, I think, or 302. 307. 307. She was found injured, she was pregnant, she was found injured in a railway track. A knife was recovered from the place of occurrence. Now, husband is convicted. On the basis of some hearsay evidence, she has not come before the court to depose that he inflicted the injury, but remains. And all are hearsay. We know they are husband and wife. So we are granting the bail. Heard Mr. A. Is he here?
He is in court 17.
Okay. Heard Mr. A. Thor for the we are learned counsel for the applicant. The present application is also heard Mr. R. Borua, learned electoral professional. The present application is filed under section 389 file of full stop. The peruse the statement of the LCR is there, na? I have seen in there. Give it.
As
Peruse
per the
the-
LCR is there.
Yeah, I have seen it. I have seen it. Peruse the LCR full stop. From the LCR, it is seen that the injured victim wife has not been examined by the prosecution, though the allegation and conviction is under section 307 IPC. The petitioner has been convicted on the basis of some witnesses. Most of them are testified and their testimonies are hearsay testimony. Full stop. Considering the except one witness who testified that the victim lady has informed her that it is the present accused who inflicted the injury. However, the victim has not opted to appear before the trial court and to testify her case. In view of the aforesaid, its court is of the view that the petitioner has been able to make out a case of acquittal. Accordingly, the present application is stands allowed to the satisfaction of three. I stands disposed of and main case as LCR has been received, list this matter for hearing in the usual in its. I am surprised. Can a person be convicted like this? Not a single witness. He might have done it. We do not know. Not a single witness. Yes.
May it please your lordship.
Yes.
My vehicle was seized.
Lordship, I am appearing on behalf of Special PP Wildlife. He's out of station today. Lordship may fix it next Monday or Tuesday.
When
Coming Monday or Tuesday. Lord.
you want, what is the question? This is quashing.
It's your lordship, yes, passing, and your lordship may kindly, I have an interim pair, your lordship, my vehicle.
Jimma.
Jimma of my vehicle. your
Okay,
lordship.
when?
This coming Monday, Lordship may
Okay,
fix.
Tuesday.
Deep.
Mr. Deuri, when your names are shown, why don't you appear? Yesterday, there was a criminal petition. On 4 occasions, your name is there. You have not appeared. At least inform the court that my brief has been taken back.
Sorry, your lordship, maybe.
On 4 occasions, and we have dismissed it. We're relying on a Supreme Court judgment that it can be. Nowadays, there is a recent judgment where it says that revision petition can be decided on merit in absence of either of the petitioner or the lawyer. This is not expected from you.
No, I'm extremely sorry, your lordship.
Not only one day, on last 3 occasions you have not appeared. Yes. At least tell us that no, my brief has been taken. You can record it.
I have missed out, your lordship.
Have you missed out in 3 occasions?
Can be taken up at 2 p.m.
Can be taken. It will be taken up after vacation. Huh?
I'll buy.
After vacation.
No, but I have some.
Why are you insisting all this before vacation?
Malat,
this case,
Mr. Das, lawyers are now changed.
The petitioner which was while the incident took place, he was the incident entity. He has been prosecuted without sanction. Against
No time to write judgment. See, 2019, how many methods? on to-
there is no interim order. He is facing the trial. Without any sanction, he is facing the trial.
You'll be acquitted, acquitted.
But they cannot prosecute him. Under
Not today.
there is a bar
Not
under
today.
197.
Pura, don't you need
We
any
have
attorney?
to go. We have to go through the
Yeah.
record.
Help me. The,
I have some urgency.
yes, you have urgency, I understand. But there are specific allegations against you. Sanction point we do not know. But there is specific allegation in the case diary against you.
In the FIR, nothing is there. In the FIR, nothing is there.
FIR is not encyclopedia. All 161 statement. I did my homework.
Can I pray, my lord?
But problem is that to write a judgment either in your favor or against you will take some time. Ultimately, your anxiety will remain. We will have to make it shape. Either way. So your anxiety that we have expressed will remain.
Can I pray for interim order, my lord? Still, my lord, accept my.
It's
Because he has to
difficult.
appear-
Instead of
These are-
passing an interim order, we can decide it.
These are retired government servant now, my lord. At this point of time, my lord, he was working. Now he is there.
Not possible. Otherwise, see, I do not hesitate to take up matters. Mr. R. Borua, Learned Counsel, Additional Public Prosecutor submits that he want to go through the case scan copies report, scan copies received to assist this court. Prayer is allowed. List this matter on immediately on reappeal.
7-11.
So you just go through it, sir.
My lord. Right. 7-11. Oblige, my lord.
Yes,
This is your lordship, criminal petition filed for quashing the GR case.
yes. Other side's name is shown.
In this case, your lordship, response number 2 has filed affidavit, your lordship, saying that he is not willing to proceed with
That we have seen. Where is the council?
counsel.
Let the council come.
That's why. We have seen that affidavit. She married something like
She
this.
married,
She
and
got
petitioner
married.
also got married, your.
Huh?
And
She
this
got married.
stated
She
that in
she
the-
said
it will
that
not
I am
go.
happily.
Yes.
And initially, even their marriage was not even consummated.
Yes.
They got under special
Special
marriage
marriage
act. Then they were supposed to socially married. In the meantime, demand came.
Yes.
And where is the other side? Bring him. We'll dispose it of.
Lordship is taken today.
Today itself. Today we'll dispose it of.
Yeah.
Call him, so that we can record. This is not the case before wedding. Yes,
Lordship, I am appearing on behalf of the arguing counsel and he is out of station, so the matter may be
You
fixed
are-
after.
enjoying its stay.
They are enjoying it.
And there are some specific environments. We'll have to interpret those environments.
My lord,
So if those environments, more particularly in paragraph, so anyway, we'll have to write all along the.
my lord, I have my citations ready. Your lordship gives me a date after the case.
Okay.
After 13 maybe,
The
Lordship.
learned counsel for the petitioner submit that they have some difficulty today in arguing the case. Accordingly, press for an adjournment. However, Mr. Chakraborty, learned counsel appearing for the respondent, has
Respondent two.
respondent number 2 has expressed urgency in this matter as the entire proceeding of the complaint case is state by court. Considering the above, let this matter, considering the prayer of the learned counsel for the petitioner, the matter says adjourned. However, considering the urgency expressed by Mr. Chakraborty, let this matter be listed on 16/11.
Obliged.
Anything survives?
The matter of 2008,
Uh.
maybe already will not release.
Release.
But only thing is this, there will be a stigma. Stigma.
He did it, but no evidence.
No evidence.
It's a case of no evidence.
No evidence, PWT only because of the dying declaration. What, my lord, on the basis of the dying, that is by PW2, what is stated is a wife, possesses a pregnancy. Now pregnancy, the seizure is of a lucky. Seizure witness also doesn't say anything about that.
I've seen that.
And yes, your
PW2,
lordship has not proven.
PW4, only implicated by PW2, PW4 and PW3. But
PW4 also didn't say because he's a hearsay only. Hearsay. Second is what? He has been treated and FIR has
now
been
what
got-
to do, tell us. 2010 matter.
2008, 2010,
2008,
8.
10 years. There is no stay.
No state. I may be released, that's why I have.
You are also not aware.
Maybe
We'll
released.
close it. That he is not pressing. Have an instruction. Why should we write such a long judgment? Instead of taking.
For your lordship, it will not be a long judgment. It will be, it's just only paragraph, only on the basis of PW2. So the so-called dying declaration.
Nothing is there.
Nothing
I've
is there,
seen
so
it.
that the dying
Nothing
declaration
is
is
there.
concerned.
He ought not to have spent 10 years in jail. Nothing is there.
None.
He might have done it, but
Might.
we cannot go through all those he might have.
So it cannot be a presumption and assumption.
Cannot be a presumption.
Presumption. So for the criminal cases.
Because the two stories, one that she delivered in the residence itself. Somebody says that Dhai was brought in. Somebody says that due to his injury inflicted upon her, she died and the premature delivery was there. But nobody has seen it, no witness. Seizure is also a lathi, and whether only on the ground that who was that before whom it was stated.
PWT is the father. The father,
Hmm.
what is said that because it's not an, in my respect, it's not a dying declaration also. Because there is no hard and fast rule for a dying declaration.
What he said, PW2?
Who says that that he has been beaten there after having a alcohol, having a
No, see, he says that there is a habit of beating.
Yes.
Is it said that on that day?
no, that doesn't there.
That is that
That is
there is
not
a
there.
beating habit. He sometimes beats her. So I have heard that she was beaten. So I went there and
Yes,
found her.
absolutely correct.
That is
Yes,
this
yes.
is-
Yes.
what to do.
No, my lord, suppose my lord, he has already completed
he-
sentence.
Uh,
He was then released from the jail, lordship. Whether writing any judgment, it will give any fruitful result. to the
and
matter.
he is not a person of that he will non place for the appellant at all. Is better after. So now let me complete all the things. All is time being. Will not all time. Time being. We'll finish it up and because all this bail which we have allowed, it should be uploaded at the earliest, so that at least they get the certified copy today itself. Otherwise, 2 more days they will be inside. Left over.
At 2 p.m. Lordship.
And again you will bring me at 2. Recovered.
Recovered, my lord. I have stated in paragraph 7, lordship, and in paragraph 5 also. Lordship, the wife of the petitioner died, lordship, who is the elder sister of the so-called victim. And
So you started when she died.
lordship, I have stated in paragraph 5, 4/9/2023.
4/9/2023.
2023.
And when the incident happened?
30 9/23.
So you have not waited for even a month.
Lordship, she come of her own to look after her
What is the
niece.
rest 19?
Lordship, age would be 19, Lordship. But in the FIR, it is written as 16. Since she is measured,
How
Lordship,
many days you are inside?
Lordship, on 1st of this month, Lordship, I have been arrested.
Where have you stated that your wife died?
Lordship, paragraph 5, my lord. Paragraph 5, page 4. May I read, my lord?
Hmm.
The petitioner states that on 4/9/2023, his wife, namely Alima Khatun,
So
elder
this
sister of
continued during her
she left behind her 3 minor child.
considering the period of detention and the nature of allegation and the specific statement made in the paragraph 5 and 6 of the petition, the court is of the view that no further task is necessary. To the satisfaction of
20,000. Acha. CGM South Chal.
CTM.
Abla Jal.
Yes.
Criminal revision petition lordship.
Yes.
Page 15 is the impugn judgment lordship. Only 1 year. lordship. So LCM may be called for lordship.
Where is the IA?
In the main petition also I have paid.
Any affidavit?
Page 14 lordship.
Page 14. You note it. Is an application. Where is your affidavit?
Page 16 lordship.
Page
16.
Revision.
Okay. Here we will issue notice only, huh? Then we'll state.
Lordship.
Huh? Notice against the two judgments. So therefore, considering the period of sentence and nature of allegation and the materials available on record, the impugned judgment sentence are state.
I am
to senior counsel.
Oh, there is one fight is still there. And others are over.
Scan copy was called for lordship.
Lordship, I was on bail, your lordship. It's a matter of 2015. Your lordship, going by my age now, your lordship, I was around 20 years old then, your lordship. Your lordship, due to the COVID and all, your lordship, I never received any summon, neither received anything, your lordship, on 2/8 of this year, your lordship. I was picked up, your lordship. I'm behind the bar for 70 days, more than 70 days now, your lordship, 71 days.
The matter has been surseated lordship under section 302 also. Here edit.
Your lordship, allegation is that, your lordship, if your lordship goes to the FIR, your lordship, some people hired the car, thereafter the car and the person were missing, your lordship. And there is no specific allegation thereafter. I have, then I was out on bail, your lordship. And your lordship, I have
Now the
stated,
case is pending at a stage of consideration of charge.
lordship,
Is yet to be framed.
Have you appeared? Have you approached the trial court?
yes, your lordship.
Rejected.
Yes, your lordship. Your lordship, I have even stated before the case was committed, your lordship, that NVW was not received by me, your lordship. I was not aware of the neither any summon was issued upon me, your lordship. Thereafter, when the case was committed, your lordship, before the section judge, I have also filed bail application before the section judge, your lordship.
Now the very nascent stage of trial proceeding. Charges are yet to be framed.
Your lordship, any condition may be
Where,
imposed.
where
02
is
is
your
involved.
order granting bail to you?
Your lordship will, your lordship, I have not annexed it, but your lordship will find on page 25. Page 25, yes, the lord.
Page 25 of
Your lordship, BA 3516.
PA
Sorry, your lordship, BA 3443, for item 16.
page.
Your
Page
lordship
25, item 16.
your lordship will find
Yes, sir. Page 25. Your Lordship, last line, 25 below. The accused Asikul Islam, though on court bail, jumped the bail even after receiving the summons.
Both the persons are prosecuted under section 390 to 301 and 201.
302 was later added, Your Lordship. What is the allegation? What is the findings against this man? Your Lordship, there is no. It is not readable.
One person
There's
who's
no
already
specific
died, Lord.
allegation, Your Lordship. Huh? One person died, Your Lordship. That there are 3 persons. He is the youngest, Your Lordship. Youngest is not the issue. Yes, Your Lordship.
So we need a status report of that.
Huh?
We need a status report on it. The picture is not clear.
Not clear.
Yes.
What is your name? Your Lordship, Asikul Islam.
17 Lord Muhammad Salu Salamuddin.
Any 164 statement?
No.
We'll take it after vacation. The airport from this.
By the time Lordship status report may be called for.
Okay. So the 10 copies of case diary is received. The same is not readable accordingly. What to do?
Status report regarding the present
Accordingly, a
status.
status report from a status report we call for by the registry.
Okay.
Is this matter on?
Lordship, on 15/11.
15/11. So it will be another around more than a month. Yeah, you have done it something. Not that you have not done. Your Lordship, no, only on doubt, Your Lordship. Only on doubt, Your Lordship. Because Your Lordship, just by our this was that we have the report
We have
will
hired
not
a
come immediately.
Yes.
If you can help us, a copy has been served to other accused. Have the copy, file an affidavit so that we can take a reasonable decision.
Yes.
I have not been able to read anything. How can I pass an order? And if we call for the scan copy, same will come.
Same will.
If you have a copy file before vacation, we'll take it up. Possible? See, to pass an order, at least we must have something. We'll have to give the reason.
Yes.
It is not readable. File the affidavit before vacation. Let the matter come up immediately after. Okay. Not readable. However, not readable. The status report we call for. However, the learned counsel for the petitioner submits that he will try to have the copies of the case diary, not case diary, copies of the 161 statement. 161 statement will not be provided. Because this will be copy will be given. It's a copy The stage is over.
Lordship, the court,
Perhaps-
actually, Lordship, the trial court, Lordship, they don't, agree to provide 161, even sometimes.
It will be given to the other accused. Nah, you are not appearing. I think copy is only, that is fixed for what?
And for status report.
There is no other accused.
Then from where will you file?
So we'll have to apply for those copies, Your Lordship, but 161 and
Will not
164,
be given.
they don't give it.
If we call for the original case, then the proceeding will be stayed.
State.
Again, you will be in the jail. Registry shall obtain a status report as well as obtain afresh the copy of the case diary,
Yes.
which is readable. Can go. List this matter after
9/11.
9/11.
Okay.
Otherwise, I've not got anything.
Yes.
Next case.
My lord, here in this case, my lord, there is a land dispute, my lord, between the petitioner and the informant.
Mhm.
And
It
their
is there.
cousin brother also.
It is there, man.
And their cousin brother, petitioner and informant, and the petitioner also, my lord, file on title suit, that title suit is pending. During pendency of the title suit, my lord, the informant side, my lord, constructed one temporary house over the disputed land. And suddenly, my lord,
Fire is, there is
Yes.
allegation of
Burning,
put-
man.
that is the allegation.
Prior to the household, man. Then the complainant, man, he says that he have witnessed two person, that is one him and another one is not before your lordship, my lord. They're running away. And other witnesses said that, my lord, he has informed them that this person has fled from the scene after lighting the.
Nobody has seen them.
Nobody except the, my lord, complainant, man.
Explain what the complainant say.
Complainant says, my lord, the গাঁৱৰ পদকীয়াখনে ক্ৰমে আজহাৰুদ্দিন শেখ আৰু জহিৰুদ্দিন মুন্সি পূৰ্ব পৰিকল্পিতভাৱে মোৰ পিতৃ ইমান প্ৰাণে মৰা উদ্দেশ্যে পিতৃ মাতৃ শুই থকা অৱস্থাত জুই লগাই দিয়ে। And
He says that
More-
where was he?
জুই জ্বলি থকা সময়ত মোৰ পিতৃ মাতৃ থিয় বাসৰ কৰাত মই ঘটনাস্থলীত উপস্থিত হওঁতে ঘটনাস্থলীৰ পৰা আসামীগণক দৌৰি পলাই যোৱা দেখা পাওঁ।
This is the informant. And what is the other?
Other says that, my lord, he was informed by this person, my lord, informant, that he saw this petitioner running from the scene. Here.
No other.
No.
What to do?
Because
And the other case there,
other cases is not received. Only one is only one PT.
one city was
Yes, my lord.
Yes, my lord, actually,
considering the material available on record,
They have suspected that
record 16 that the petitioner is on the consider material on record is put of the view that no custodial interrogation should be required. And also other deputies at stage of investigation. However, they will appear before the IO within a period of 10 days to record their statement. And certainly keep recovered.
I have not yet received, my lord, regarding whether recovered. I have called
Huh?
for paragraph number 5. I have called
Paragraph number
5.
one thing I'm getting a problem. If
No.
it inform your IO, while this kind of cases, while arresting and forwarding before the court, they should at least give a note that whether girl is recovered from his possession or not yet recovered. That is very vital.
Very vital.
Even in most of this, I have seen the forwarding report, there is no date and time of arrest.
Forwarding, yes, sometimes.
Because these cases, it is important
Yes.
that whether recovered. If it is
Yes.
recovered,
Yes.
we may consider The girl is recovered, he is inside for 30-40 days.
Yes, forwarding at least has to be there.
In the case in forwarding, you put nothing.
Nothing is there, that's why. That's why we marked the question whether recovered.
Whether it can be tomorrow. Just for that instance. Yes,
Statement under 164 also recorded.
as per his person.
His part.
Yes.
Okay, will you have the instruction?
Tomorrow.
Yeah, because otherwise we are coming back at 2.
So yes, then if it is comes, well, it comes.
Then we'll see at 2. At 2, or if Mr. K.N. Chaudhary and
Yes,
he does come, then we'll be here. Our list is over. Inform them. They may be free because we call them at 2. See them.
From the counsel of the other side, he is on leg in court number 3.
We thought that we'll finish it up
Yes.
again. You will have to again come.
Sets the mind.
Pura?
CGM Bazar.
CGM Bazar. Yeah.
I appear on behalf of H.F. Palwar Milot, who is suffering from illness. Milot. As per his instruction, Milot, matter were amicably settled. The responsible to seek what merit to another person.
Lakshmi Narayan. Hey, at the order of your past.
Oblige.
You have already been arrested, released on bail.
No. We have not been arrested, my lord. The main person has been arrested. If your lordship will kindly come to the complaint, my lord.
Who are you?
I
You are
am
Deepsika.
Deepsika. I was, my lord, engaged as a consultant.
You are Deepsika.
Deepsika. Page 36.
What is the stage of the investigation?
Investigation is going on, my lord. Moreover, one of the co-accused who filed an bail application was the inquiry, but our argument is concluded the case that is court number 18 and it's for delivery of the case is delivered as per case in court number.
Okay, what I was thinking is to look into the case diary and
No, my lord, here my case is very simple. Even if we assume, my lord, the allegations are correct, it does
there
not
is
make
no
out
case.
any.
But what about
So first of all, my lord, to invoke section 405, there must be an allegation of entrustment.
what are the sections?
My lord, 406, 419 and 420. Where is the entrustment?
Only a specific allegation is the stolen. No.
And my lord, I must go down inside that Pathak who is inside. I'll show the agreement, my lord, what is my role. It's absolutely an abuse of the process. If your lordship kindly permits me to read the FIR, then my lord, everything will be clear.
Yes.
With due regard, I beg to state that I am authorized representative of Hudson Food Private Limited, having its head office at Bengal Eco Intelligence Park, Kolkata, and of its branch office at first floor of so. Our company deals with poultry feeds and has manufacturing plant at Raninagar Industrial Estate near New Jalpaiguri, West Bengal. In order to cater our supplies at Guwahati and other adjoining places, we have taken on rent a godown located at Punapur. One Nilang Kashyap was introduced to us around 5 years back, and he maintained constant touch with us and requested to appoint him as our representative for northeastern states of India. However, Mr. Kaisab stated that he was working with the CID and therefore wanted that Deepshika Chaudhary, one of his close allies, be appointed as consultant for managing all our operations in the northeastern states, including Assam. The process maintained by us for carrying out our business through our Guwahati office was that orders were procured by the Guwahati office and were sent to Kolkata head office with detailed name of the customer, along with his address, items to be dispersed with grade. The head office used to issue delivery order for dispatch of goods from Raninagar plant Jalpaiguri to godown located at Sonapur, Guwahati on the basis of the order raised by the Guwahati branch office. Mr. Nilang Kaishyap on several dates, that is on so communicated orders of different poultry commodities. The goods were transported from our factory to Guwahati, stocked at our godown located at Sonapur, were supposed to be sold immediately to the customers against whom the orders were booked by the Guwahati office. Now kindly see, the stocks were received in the Guwahati godown by one employee of Guwahati office, Bhavan Pathak, who certified that stock was so and so is in stock godown on so and so. So, their specific case is the entrustment acquired the goods were with this Bhavan Pathak. But we were surprised that there was no request from Guwahati office for issue of invoice to customers, and neither was any indication of payment against the same. We had doubt in our mind as transportation of goods were made on the basis of the orders placed by Nilang Kaishyap under authority of Mrs. Deepika Chaudhary, who at the relevant point of time was officiating as consultant of our company and was responsible for managing all operations at Guwahati for the northeast of India. We doubted some foul play, and accordingly, we all of a sudden made a surprise visit on 21st at Sonapur godown to take a stock of the stock supposed to be available in the godown as per the stock statement of Bhavan Pathak. We were surprised to find there was no stock of product in our godown, and Nilang Kaishyap together with Deepshika were found absent. On being inquired, Bhavan Pathak, who received the stock, could not give any explanation in regard to the missing stock. Thereafter, the undersigned called Nilang Kaishyap for discussing about the issue when he expressed his anger as to why he had come to Guwahati without his permission, and I will face dire consequence if he went to the company office in Bapistapur or Sonapur godown. The undersigned felt afraid and refrained from going there. After a great persuasion with Kaishyap about missing of goods from Sonapur godown, he simply said that goods have been sold and he will inform details of sale after receiving payment. On challenging, he refused to cooperate and refused to divulge details of the transaction done by him. For so and so remove poultry feed removed from the godown by him, etc., etc. As the informant innocently believed Nilang Kaishyap and thought he would be certainly deposit the amount in the account of the company, the informant waited for a reasonable time and provided him opportunity to refund the money. But Nilang Kaishyap has not only failed to deposit the money, but he has cut short all the communications with the informant. Nilang Kaishyap and Deepika Chaudhary have breached our trust and stolen the goods from Sonapur godown. It is now clear as to us that they had then other directors of Sonali Food and Feeds Limited has removed the goods and sold the same in market. Moreover, the bilty used as proof of receipt for the transport was consistently stamped by Sonali Food Products, indicating that the goods were received by their company instead of our office in Guwahati. This clearly points to their complicity in the theft and unauthorized sale of our product. Bhavan Pathak was in charge of the stock, highly similar. Receiving and the sales, he is so deeply involved with them in the theft of the goods. Since then, Bhavan is also not with them. It was worth mentioning here that for the purpose of carrying out day-to-day operation, a Bolero vehicle bearing registration numbers in the name of so was kept for official use by the company's director to Guwahati. Nilang Kaishyap, without information to us, is using the same vehicle for his personal purpose. And despite several requests by the informant to return the said vehicle, the accused still then is using the same without having any legal right to possess that same. We earnestly urge the authorities to thoroughly investigate this matter, facilitate recovery of damages, and hold those responsible accountable for losses incurred by by our business. We are fully committed to cooperating with the etc. Now, my lord, as far as the present petitioner before lordship is concerned, there is absolutely no allegation other than this sentence, my lord, at page number
39.
37. That Deepsika, one of his close allies, be appointed as consultant for managing all our operations in North. Now, my lord, let us see.
And there is a allegation at page 39
Yes,
that Nilanka and Dipriya Chaudhary
have
have
breached
breached
our
our
trust.
trust and stolen the goods from
Good.
Sonapur.
Now,
But
what is that
stealing
breach?
is 379 not registered.
Not there. Now, my lord will kindly come to that agreement for a moment. Page 44. By which, my lord, and interestingly, my lord, this is a document registered in Jaipur. We stay in, my lord, Guwahati. The owner is from Calcutta. The factory is in, my lord, Jalpaiguri. How come this agreement was executed in, my lord? My lord, this also shows enough, my lord, suspicious circumstances. Now, my lord will kindly come to page number.
Report.
1 second. Agreement.
Page
25. No, my lord will kindly come to page 30. The original one. Scope of work. My lord may kindly come to 29. This is the first page. They, my lord, seek to rely authority from this agreement. They would like to, entangle the petitioner by virtue of this agreement. So let us see, my lord, what is the scope of this agreement. This consultant engagement agreement, lordship, if we go by the literal dictionary meaning of consultant, he has got nothing to do with, my lord, sale or receiving goods. For him, there are separate offices there. Now at Jaipur. Now, whereas the consultant wishes to provide the services as set forth at Appendix A. Now, my lord will kindly come to page 30. Consultant agrees to provide the services to the company in relation to their page 30, my lord, on top. The consultant agrees to provide the services to the company in relation to their operation based in Northeastern region. In the event that additional assignments are agreed upon between the consultant and the company, parties shall do so in writing describing the additional assignment, including fee and schedule for specific assignment. Consultant shall provide budget and schedule for completion of due execution and performance of service, and a contract on a contract basis during the term and tenure of this agreement. Company agrees to provide any necessary information as has been considered necessary by the board of directors, material documents and approvals needed by a consultant to perform the services outlined in any timely manner in relation to operations limited to the consultant. And my lord will kindly come to page number 33, Appendix A. Market development for sale of animal feeds, liaising with dealers and salesperson, risk assessment of prospective dealer and stakeholders, to act under board of directors and be overall in charge of ethical norms of all employees of the company for operation. So I, as a consultant, my lord, duty cannot be cast upon me that to collect the sale proceeds and remit it to the company. And it is not the allegation that the goods were delivered to us. Goods were delivered
to
you, me. Goods were delivered to the godown of which Bhavan Pathak is the in charge. And Bhavan Pathak has been arrested. Now, my lord, will kindly come to the and my lord will kindly come to page 31 for a moment. Or B, my lord. The consultant also agrees not
Oh.
to be treated
4B.
for B, my lord, small b. The
Yes,
consultant
yes,
also
yes.
agrees,
Yes.
31.
Same thing.
Consultant also agrees not to be treated or seek to be treated as an employee of the company for any purpose, including for the purpose of fringe benefit provided for the company, for disability income, taxes, and consultants, employees and subcontractors shall also not be deemed to be employee of the company for any reason whatsoever. Consultant hereby represents that the consultant has and all times will maintain timely payment of taxes due to the income tax department and all other government agencies, including withholding of all other taxes. My lord, there is no scope to find me guilty of collection of sale proceeds and remitting it to the authority. My lord will kindly come to page 55. This is a delivery note, my lord. Kindly see on left-hand side top, consignee, Hudson Food Products Private Limited. Buyer bill, Hudson Food Private Limited. So, principal to principal or principal to agent at best. Destination Sonapur. There go down. Then please come to page 56, my lord. Consignee, Hudson Foods Private Limited. Buyer, Hudson Foods Private Limited.
Page?
Page 56, next page. So the goods are being sent from their one office to another office of the same entity, my lord. Similar is page 57. Hudson Foods Private Limited, Hudson Foods Private Limited. Something like, my lord, the manufacturer is sending to his, my lord, maybe distributor, selling agent, etc. On these materials, my lord, how can there be an allegation of criminal breach of trust? Or for that matter, my lord, cheating. Where is the allegation that we had the intention from the very beginning? That's a requirement. Page 58, page 59, page 60. These are all, my lord.
Yes, that's.
Therefore, my humble submission, my lord, there is absolutely nothing in this.
Yes, made out.
Absolutely,
Subject to what?
absolutely not. I
Subject-
just say one thing. My lord, first is that it should be rejected on the ground of suppression of material fact. One, there was a bail application which was moved by Deepika before this court. AB was moved. I can show it. AB, when it was moved before this court, my lord, no interim order was passed. Court said that there was some material, we have to look in the case diary. On the second day, I'll show, my lord, the bail application was, AB was withdrawn.
But he,
Number
bail has
one.
been granted.
No, I'll tell your lord. Then thereafter, they moved before the sessions court. And in the sessions court, the interim bail was granted. But interim bail was granted, but not a single whisper regarding moving of bail application before the High Court. And on that case, PP has conceded before the sessions court. And the case diary, call for the case diary, it has been fixed on 19. On 19, it has been fixed. Now, they have come and filed for questioning of the
19
question,
fixed for what?
19 for case diary
Where?
before the sessions court.
But there is a bail order, I think.
Yes, there is an interim bail order.
Interim order.
But case diary would have to be looked into by the sessions court. The court has looked into it. Court, there is a suppression of material. I have given answer. Suppression of material fact that they have moved the High Court, they have not mentioned. Only they have annexed the interim bail which was granted by the sessions court, where they have mentioned that they have moved before the High Court in the London sessions court, or they have not mentioned. Now, my lord, the case diary has been fixed on 19th of this month. and the case diary has to be looked into by the learned sessions court. In the meantime, they have filed this application number 482. So number one, my lord, the court has to look into it at this stage, my lord, whether 482, yes, he can come. What will be the stage of that antecedent bail which is pending before the learned session court in the case that he has been called for? Your lordship, that has squarely decided by the apex court first. Forget about for a moment what the law says, my lord. Kindly look into the judgment of Niharika, my lord. What the law says.
56 report, subpara 4.
16. Kindly see 16. Kindly see. Kindly see 16. What it says. Subsequently, your lordship will go into the FIR.
Subpara 4.
72, para 72, subpara 16.
Page
Is para 72, kindly see, para 72. Para 72 of Niharika. And turn 76, 77, 80. Kindly see conclusion 80. 80. And now, kindly see 16. Roman 16. Conclusion Roman 16. Roman 16. May I just read this Roman 16, man? The aforesaid parameters would be applicable and all the aforesaid aspects are required to be considered by the High Court while passing an interim order in a questing petition in excess of power under Section 482 CRPC and under Article 226 of Constitution of India. However, interim order of stay of investigation during the pendency of the questing petition can be passed with circumstance. Such an interim order should not require to be passed routinely, casually, and or mechanically. Normally, when the investigation is in progress and the facts are hazy and the entire evidence material is not before the High Court, the High Court should restrain itself from passing the interim order of not to arrest or no coercive step to be adopted, and the accused should be relegated to apply for antecedent bail under Section 438 CRPC before the competent court. The High Court shall not, and as such is not just in passing the order of and no court either during the investigation or till the investigation completed or till the final report charge sheet is filed under so and so while disposing of the questing petition under 482 or Article 226. My lord, there would have been no absolute problem if, my lord, the antecedent bail, my lord, is now under consideration before the trial court. And the case that he has been called for, the investigation is in progress. So, at this situation, my lord, when the matter was pending, my lord, there is absolutely no bar of 482. But here the case that he has been called for, the investigation is in progress. The court will look into what is there in the case diary. Now let us now go what is there in the contents of the FIR. It's a disputed question, my lord. It's a disputed question of facts. Kindly see, my lord, what it says. Kindly see the FIR. Page 36, it starts. 36, my lord. Contents of the FIR. Page 45. Kindly see 45.
But where is the, we can understand regarding Nilang and
My lord,
Babon.
why not? My lord, then kindly see 45, second paragraph, last paragraph. Neelam and Dipsika Chaudhary have breached or stolen the goods from, so it is now clear that they under the directors of Sonali Foods and Feeds, in which Dipsika Chaudhary is a director, has removed the goods and sold the same in the market. My lord, what they have done?
But there is no
My
case
lord,
registered under 337.
no, I am telling 420 misappropriated. This money has, this has been sold and they have got this money. So they have misappropriated my money. So what has happened, my lord? Sonali Food is also one of, they deals with the same product. Kindly see, my lord. She is one of the director of Sonali. What they do it, my lord? It has been sent from Jabalpur, from Rana.
No, we understand. Your case is that
But
we
this secret-
appoint
my lord,
a
these are-
consultant, we send our material to you. Instead of selling in our name, you are selling in the name of
No,
the
then,
Sonar.
then my lord, and Dipshika is saying that consultant, she has to look after everything. Where is that question that she is now absolved, said, no, I am not
She was a
concerned, only
salaried person,
consultant.
1 lakh per month.
Yes, 1 lakh for that purpose. What is that? Kindly see, my lord, at page. Now my learned friend has at page 33. Kindly see page 33, my lord. Kindly see page 33. These are disputed question, my lord. Kindly see one. These are matter of evidence. One, market development for sale of animal food, feeds, licensing with dealers and salesperson, risk assessment of prospective dealer and stakeholders to act under. So everything has been entrusted.
He is not entrusted to the material.
My
It
lord,
is for the purpose of market
oh,
development.
but that means, my lord, she will not do anything. Only that she will get.
She is
So
not,
she is not.
she is not your consignee. Where
Not-
is the entrustment of the
The
property?
entrustment, why? My lord, my
She is
lord,
not your consignee.
what
Only
consignee?
making a, suppose I
Yes.
send this material to you. You sell it to the market. Sell it to the market. On, from your own record, on the basis of which you have involved her role, that itself says that products are not to be delivered to her.
No, that's fine. It has gone to the godown.
Yes.
From
So when
godown.
there is no entrustment, where is the
No,
question
no,
of misappropriation?
No, no. My lord will kindly see what have breached our trust. Kindly see there at page 45.
Your trust is to trust upon her to develop the market, licensing with dealers and salesperson, risk assessment of perspective, how whether
No,
dealer is good or bad,
her
to act under board of directors, overall in charge of
overall in charge.
of ethical norms of
Everything.
all employees. And she's
Marketing.
kind of
So
a
marketing,
HR.
marketing will include everything, my lord. She is a consultant, my lord. These are, my lord will kindly say, apparently these are the disputed question of facts, my lord. These are only to be adjudicated. And when the investigation is pending, my lord, when it is the learned trial
You
court, we
investigate.
look.
We are not stalling the investigation. We give us the city, but don't arrest her.
Then your lordship, if it is not to, she has already got the interim relief, not interim relief. So then your lordship in Niharika will be against them, my lord. What is Niharika judgment? I will just tell your lordship. Niharika, initially there was a bail application, bail application under 438 was moved before trial court. 438 interim bail was granted. 1 year interim bail enjoyed. Then they came to High Court under 482. Then there was an order passed by the Bombay High Court saying no coercive measure. No coercive measure to be not, that means not to arrest. Then what happens? Went to Supreme Court.
Then
Now Supreme Court said what? Supreme Court said when there is an interim order which has been passed. Now there is an interim order which she is already protected. Is only a matter of investigation. Now, no coercive measure, my lord, already she is protected by 438. My lord, I would have very well understood that no coercive measure can be passed by this court with a reason order. That's what Niharika says. There has to be some reason. But here, my lord, already there's a.
yes, see, Niharika judgment subject to correction is not a proposition that 482 power is curtailed.
I am not saying
This is
482.
not the proposition.
Where I am saying that.
Number one. Number two is yes, that there is a question that since already an interim order is operating, where is the question of
That's what
granting
I'm
another
That's what I'm
thing?
saying. Where is the
That
question?
can be a question. That
No,
can be
my
a
lord, what
question.
I'm saying.
But
Absolutely.
prima facie, my view, subject to further deliberation, so far relating to the present petitioner, because
Yes.
whole, if we take everything to be true in your case, and there is a recent judgment where authored by my Lord Justice Padiala, where it says you even look into the clever drafting in the
I've seen.
FIR.
2000,
Not the FIR.
2023, that judgment.
Recent judgment.
Recent judgment. I've seen.
Recent. So the law is
your lordship,
developing.
now-
Here, if we go by your contract with her, it's nowhere a case that she is entitled to deal with the product or sell it.
But my lord will.
This is one. If that entrustment by virtue of the contract is not there, where is the question of misappropriation? This is one. And no 379 is recorded. registered. Only thing is that 420.
My lord, your lordship will,
So
unless.
now
you-
answer, Mr. Chaudhary, you
Yes.
are already on interim
No, my
protection.
lord, that's not the issue. Issue is, my lord, here is a case.
Hmm.
My lord, if my learned friend is insisting on Niharika, then he cannot appear on this side. Always he'll have to appear on that side. Is that the proposition?
No, that
Huh?
is.
So
see,
is that, my lord, with all respect, my lord, tomorrow another Niharika
Oh.
will come. My lord, Bhajanlal is there. It's
No.
standing tall.
Nihar,
My lord, Bhajanlal is
husbands are
standing
like
tall.
this.
Yes.
Husbands are like
Ah.
this. Emanation
lord.
he uses today.
He, tomorrow he comes
Tomorrow
here.
he will
He
also.
always comes
Then
like
my
that
lord,
only.
Normally, I don't do that. The reason being,
Oh,
I have to balance it. My lord, we also have a duty, my lord. I'm not saying, I'm not.
Now to answer this
Yes.
question, you are already protected.
No, my lord. I am protected only by an interim order.
Ah.
That is a different jurisdiction. Here I am coming for quashing of this
But
proceedings.
suppose I.
No,
detail-
lordships will, if your lordship is satisfied
Hmm.
that prima facie no case is made out, certainly lordships will stay the further proceeding. My lord. Against me, qua the petitioner. I'm not saying against the whole affair. Qua the petitioner. I think, my lord, we have been able to make out a case for your lordship, at least interim intervention. Subject to what may follow order from the case diary and all. I think it's a clear, open and shut case. Well, Niharika cannot be pressed into service to take away your lordship's power either under 226 or under 480. Otherwise, my lord, the purpose of conferring that power will be meaningless. My lord, all said and done, we also know, my lord, my lord, one observation from a recently authored judgment of the Supreme Court.
Niharika was diluted in some other judgment.
Many cases, my lord.
Many cases.
It's out of copy. It's a judgment by Nazir
What is
Ahmed
it?
and Krishna Murari, my lord.
Subsequently, it was not diluted. Subsequently, Supreme Court said when you move for it, you have to give a reasons order.
My lord will kindly come to para 45. Applying this dictum to the instant factual matrix, it can safely be concluded that the present case clearly falls within the ambit of first, third, and fifth. First is, my lord, at the page para 44, where allegation taken in its case value do not make out a case, where uncontroverted allegation made in the affair and the evidence collected in do not disclose and commission of an offense. 5, where allegation within the affair complaint are so absurd and inherently improbable on the basis of which no prudent person can reach such a conclusion. So on these grounds, precisely same is the case here. Para 45. Recently, this court in case of so has again reiterated the long-standing principle that criminal proceeding must not be used as an instrument of harassment. There can be no doubt that jurisdiction under 482 of CRPC should be used sparingly for the purpose of preventing abuse of process of any court or otherwise to security ends of justice. Where the complaint discloses criminal offense or not depends on the nature of the allegation and whether the essential ingredients of a criminal offense are present or not has to be judged by the High Court. There can be no doubt that a complaint disclosing civil transaction may also have a criminal texture. The High Court has, however, to see whether the dispute of a civil nature has given the color of a criminal offense. In such a situation, the High Court should not hesitate to quash the criminal proceeding as held by this court in so and so. Moreover, this court has innumerable instances expressed its disapproval for imparting criminal color to a civil dispute, merely took advantage of relatively quick relief granted in a criminal case in contrast to a civil dispute. Such an exercise is nothing but an abuse of the process of law, which must be discouraged in its entirety. My lord, initiate a recovery proceeding against a person. How am I responsible for this sale proceeds, my? It is none of my part of my duty. At least
Yes, book on what you say.
My lord, your lordship, what I'll say, one more judgment, 50 judgment. See the case diary, what is there in the case diary? Normally, what is the question, my lord? Your lordship, at this stage, your lordship has to look into the case diary. Has to look into the case
Before
diary.
we'll go to the case diary, my concept of with limited knowledge is that in this case or any case otherwise, we'll have to see the case diary because FIR is not the encyclopedia. But at the same time, we'll have to see it's a detailed affair. It's not that there is a two-liner affair. How the whole transaction is done, what was the responsibility, everything is detailed in this affair. From that, the entrustment is missing upon this,
Lady.
this lady.
But your lordship will reveal not only the FIR. FIR is not the encyclopedia.
No, sir, not
What is there in the case diary?
We'll
Case
see.
diary will look
So
into it.
till then, we want to protect
Yes.
the
Already
right
it is.
under Article 21.
No, it is already protected. But one
Yes.
second, my lord, it is already protected. Already protected, my lord. Already this is protected by an interim order under 438. Already protected, my lord. My humble submission is what is protected under 438. If there would have been no protection there, of course, my lord, your lordship can pass an order for protection. Already there is an order, my lord. What if Niharika says that there is already a protection? It is not a case that the DC is not been protected. And my lord, kindly see 2017 2 SCC, what it says, my lord.
2017.
2 SCC 779. Second part, kindly. In the High Court 16,
Paragraph
16,
60.
16. In the instant case has not referred to allegation or what has come out in the investigation. It has noted that correctly that the investigation is in progress. Lordship got it?
Paragraph
16.
In the instant case.
In the instant case, the High Court has not referred to allegation or what has come out in the investigation. It has noted that correctly that the investigation is in progress and it is not appropriate to state the investigation of the case. It has disposed of the application of section 482 CRPC and while doing so, that is directed the investigating agency shall not arrest the accused person. This direction amounts to an order under section 438. Albeit without satisfaction of condition of the said provision, this is legally unacceptable. This is what the Supreme Court said, my lord. Already there is a protection, my lord. So where is the question of giving a double protection? And unless, my lord, absolutely no problem. Your lordship will look into the case diary. What is there in the case diary? Your lordship finds that there is nothing in the case diary. Of course, my lord, your lordship can invoke the power under 482 only after looking into case diary. So there are other few judgments of this over the Honorable Supreme Court, my lord. Two 2012 4 SCC 547. Kindly see para 11, my lord. Para 11. Be bearing in mind the aforesaid legal position with regard to the scope and width of the powers of the High Court under section 482. We are constrained to hold at the fact situation at hand. The impugned decision is clearly so and so. In the present case, the SP Business has merely approved the opening of an inquiry and converted into cell file. Preliminary inquiry was yet to commence and the FIR was yet to be lodged. In the first, High Court state the preliminary inquiry by interim order and then by the impugned judgment. It goes without saying that the commencement and completion of an investigation is necessary to test the veracity of the alleged commission of the offense. Any kind of hindrance or obstruction of the process of law from taking normal course without any supervening circumstances in a casual manner merely on the whims and fancies of the court tantamount to miscarriage of justice, which seems to be the case here. So let me, the investigation is going on.
There cannot be, then we'll have to conclude that there is no scope for quashing of FIR.
I am not saying that there is no scope. I'm sorry, that's not, my lord has to accept, not my learned friend. That's not the argument, what I am saying. Your lordship, what I said, 482, it's open. At what stage 482 has to be exercised? What stage? That's what I am saying, my lord. I would have no problem, my lord, if this application.
A cognizable offense is to be made out.
No, my lord, what I am saying, what is the present case? The present case that you moved an application before the learned trial court. 438, an interim bail was granted, protected. The court has fixed for the case diary. Case diary is fixed on 19. 19 the case diary. So that means they were very sure that something is there in the case diary. They want a protection from this court. So why? Already there is a protection. Already there is a protection by the learned session court, my lord. Only what the court has looked into the case diary. Tomorrow also, if your lordship 482, your lordship will look into the case diary. What is there in the case diary?
When do you get the case diary?
My lord, it is court number 8. After occasion, it was declared for delivery to court. He due to it, it was this harassment.
Now
The court has not been from this. Matter was, but case there is inside the court. Again, it was not.
Monday, Tuesday, no police.
So it's inside the
Lordship, what my prayer for lordship will look into the case diary next.
That's
week,
true, but
and thereafter,
I'm on the your FIR itself. Your specific pinpointed allegation is these two parties. And this Nayak and this insult, Pathak, pinpointed. And a casual statement is made against this lady, whereas this lady's role, you do not disown the contract. This lady's role in terms of the contract is not of the godown.
this is my argument, my lord. Ultimate your lordship of pass an order.
Correct.
What we can
But
do.
we need assistance.
No, that's
We do
why I
not
have given
want to
assistance,
commit
my
mistake.
My lord, I opened up my argument, then my learned friend made his argument, then I never, now again I'll have to argue, because he's gone arguing. This is not the way, my lord.
What is gone
My lord,
argument?
yes.
What gone
No,
argument? The court
please,
is asking.
please.
I am giving the judgment.
Yourself.
Please,
What
please.
use yourself? I am passing the judgment to the
No,
court.
no, no.
No, why?
No, my
I
lord,
will
there is
not.
a procedure.
Please,
I am a
procedure.
petitioner,
No,
I'll
Please,
open.
I'll not hear.
No, no,
I'll not hear then. I'll not hear. Yes, Mr. Pukar.
My lord, I have to clarify some important things. So, but my lord, my land is already there. Here, lordship may see paragraph 6 and 7 of the petition. Paragraph 6 says, my lord, the petitioner is giving investigation to be arrested.
Paragraph
Paragraph 6, my lord, page 8.
of the petition.
Here it says, my lord, the petitioner begs to state that during investigation to be arrested, accused Pawan Pathak. Pawan Pathak is the, my lord, employee of the my lord, the present petition. And
No, no, where from this statement is made?
I made this statement from the case diary. Please do not.
Please,
Let me submit.
Right.
Okay, okay.
I'm not submitting from the air mic. What
Okay.
I'm submitting, my lord,
So who is Baban Pathak?
my lord,
Who
it
is
is an, my lord, see, it is a family record. These petitioners, Nilang Kashyap, and Nilang Kashyap and Nilam Medi is the same in one person. And the Sudarshan Medi, who was already been arrested, he was languishing in jail for 51 days. Thereafter, this Honorable Guwahati High Court released on bail. And Pawan Pathak is the employee. It's a family record. They have not only cheated this company, my lord, they have cheated many companies. It's revealed from the case diary. I have gone through the case diary, my lord. That's why I'm saying, let me speak for what is in the case diary. And your lordship may say, how suppressed? There are 7 days a petitioner begs to state that and appear. But where my lord, they did not say, my lord, they have approached this Honorable Court for bail application. And this is the bail application, my lord, where his name, her name was the Dipsi Hisa. And even in the lower court, Dipsika name written as Dipsi Hisa. And they annexed this judgments, my lord, the order of the learned trial court. And they have filed these petitions, my lord, on 29/8/23. And this Honorable Court on 29/8/2023. They're both the orders there, my lord. Initially, this Honorable Court, after perusing the FIR and the argument both sides, my lord, inclined to pass an interim order. Next day, immediately they withdraw the petition. These are the two, my lord. Next day, immediately, they withdraw the said petition and they move before the learned trial court. And learned trial court, my lord, they have approached that one of the co-accused, this Deepsika is, my lord, Nilang Kaisap's sister-in-law. They approached the learned trial court. They say that one of the co-accused are already granted bail from this Honorable High Court. And your lordship may see the interim order which was passed by the learned trial court, your lord, at page 50. How they play with the court, my lord, your lordship may say. They are the, even my lord, Nilang Kaisap, he has been in. He represents before the company as a Nilang Kaisap. His name is Nilam Mehdi. And his name also, my lord, Deepjuti Mehdi. Deepjuti Mehdi, Nilang Kaisap and Nilam Mehdi, same in one person. But affidavit, when he filed this application before the honorable court, they say that I don't know who is Nilan
Whether
Kaisa.
in the bail filed in the lower court, there is a statement that they have filed and withdrawn the bail petition.
No, man, that is not there. They simply say that Honorable High Court passed an order. One of the co-accused, he was already granted bail. That's why-
Regarding their withdrawal.
Yes, no, not regarding their report. They did not
Yes,
disclose
sir,
anything.
for Ali, do you have the bail application?
Yes, and moreover, my lord, kindly see the order. Your order, everything is very clear, my lord. I'll read at page 50. Yes, at page 50, you also missing.
But that record, we don't have some other lawyer move that.
Because
My
he
lord, they
appeared.
suppress of the many material facts, and moreover, the Nilam Mehdi, my lord, his brother-in-law, my lord. Before this honorable court, my lord, Rosim Messi, it may be taken an inquiry, my lord. When they filed petition, they did not disclose his name. Father's name did not disclose, simply Nilam Mehdi and address. How the filing section can pass this, my lord, petition, and even in the court also overlooked, my lord, pass an interim order. And when we have see the case diary, and even they file an additional affidavit, well, also they did not disclose his father name, and they say that Nilan Kaisap is, I don't know who is Nilan Kaisap, but his own brother is stated before the IO, the Nilan Kaisap, Nilam Mehdi, and Deputy Mehdi, same in one person.
How can you give us the city on Monday?
Monday is difficult, my lord, because inside the courtroom,
You
my
can
lord,
make a request that another case is there.
then my lord, we will try, my lord, on Monday, because when it was not, my lord, listed before this, because it was sick for delivery of order. That's why this case was kept by the, my lord, the attorney. And my lord, moreover, you also may say, the Garnet trial court pass an order on the basis of the interim order which was given by the Honorable High Court. Not here, you also may kindly see page 50. FIR has been lost so and so, and page 51, I'll read, my lord, this I can correct. It is further submitted that the 2 years back accused sees an employee, page 51, you wrote it, the relevant para. The aforesaid company of the informant, thereafter she got married and now she is 8 months so and so. It is further contained that the co-accused has already granted interim bail by the Honorable Guwahati High Court Fight Order dated 29 and 23. Under the above backdrop has prayed before the allowing the accused petitioner to go on previous bail any condition imposed by this Honorable Court. Having considered the abatement allegation such and such on such and such date passed by the Honorable High Court AB, whereby applicant Nilam Mehdi is allowed to go on interim previous bail and submission of the learned counsel of the both sides. Only basis of this, my lord, when the Honorable High Court pass an order regarding the co-accused, that's why this interim has been granted. And because we have to see, my lord, the Nilam Mehdi, who have fraudulently taken this interim order from this Honorable High Court,
Where is that Nilam Mehdi's bail? What happened?
Here, it is here, man. This is the bail application of Nilam Mehdi, my lord.
Whether that interim is continuing?
No, my lord. Our argument has concluded it is delivery for order. We have pointed out before the Honorable Court, my lord. He on oath file an affidavit, he said, I don't know who is Nilan Kaisa. I am not. My name is not in the FIR. Then we have told the case diary. I have presented before the Honorable Court, my lord. Why he disclosed his name? He did not disclose his father name. Later on, court pressurized. You say your father name. Then only he said yes. Promote met him. His own brother, my lord, said that Nilam Mehdi, Nilan Kaisa. It isn't meant family record, my lord. The present petitioner is, my lord, the sister-in-law of the Nilan Kaisa. And Sudarshan Mehdi, my lord, he is the brother, own brother. He was in jail. Now he is released on bail after 51 days. And the Bhavan Pathak is the employee of the, my lord, this Nilan Kaisa, Sudarshan Mehdi, and the present petitioner. And moreover, my lordship may see, when they file a petition before the High Court, her name has been changed, Deep Siha. And even in the lower court also, my lord, they have filed Deep Siha. And here we filed Deep Siha. So it's a family record, my lord. So so many materials I have found in the case diary, my lord. So
Against her, what have you found? What have you found?
He also, my lord, he under
What is
conspiracy.
her role?
Her role is, my lord, the Nilan
Or
Kaisa.
she is a scapegoat of
Yes.
their own family.
Yes, they have already, my lord, what happened?
Whether her name has been used.
Yes, her name has been used as a, my lord, director, sometimes, my lord, the consultant, and they, the Nilan Kaisa himself introduced as a
So
CID
she is
officer.
also a victim of their bad thing.
My lord, maybe he also very, my lord, said commissions, my lord. He also involved because they know her husband, how is he or he.
Where till when your interim order is there? 19.
19, my lord.
19.
19.
Because
You try to have the case.
No, my lord, if what my learned friend has said is correct, it's a very serious matter.
Hmm.
There can be no manner of.
No, man.
Unlike my learned friend, my lord, I will not support such petition. But my lord, since my learned friend has said with so much openness and boldness,
Hmm.
I think he should also take the same stand in so many cases. Where law officer of a state moves a criminal petition against the state, where my learned friend supports, when there is my lord principles emotion goes there. Where it goes. My learned friend recently appeared in a case of a defalcation
Don't
of
say where
65 crore.
I have not.
No, say, recently, my learned friend has appeared in a case
Don't be
where,
so upset.
where my lord
This is a case.
65 crore embezzlement, he appeared for the petitioner. And we also know in what circumstances and how it was appeared. And bail was granted by this honorable court. Tell me, my lord, if what my learned friend is correct,
You
my
try to have
my
the case
client
diary.
does not deserve any relief.
If that being so, you are on interim protection. You
Yes.
are fixing it on Tuesday.
First time,
You have the case diary. You can very well will return
This-
it back if it is
This
not in order.
fairness and this uprightness should be in every case, not in some selected cases.
Let it be fixed on Wednesday. man.
Let it be fixed after vacation. my lord.
Wednesday.
Then my learned friend will be happy.
Wednesday.
No. Wednesday.
Don't say it. Don't take it. You are so
Mr.
experienced.
Das,
One
that's
second,
why I-
1 second, my lord.
please,
My learned friend
not,
is so
not
experienced.
before this
Not
court,
so
not before.
Not, my lord, we are
Have a
not,
smiling face
my lord,
like this too.
my lord, I'm saying
Always.
we are not identifying with any client. My learned friend is so
No, no, he is
experienced.
also, he is
So why
always-
you say
he's
he has
excited,
also-
he's excited.
Not excited, but I speak the truth. I don't
What
care.
truth?
I speak
What
the
truth?
truth.
We
Then
know.
we need people
Please,
to
please,
speak the
please,
truth.
Very nice.
I speak the truth.
Please.
I don't care, my lord.
On.
What opinion people forms about me.
Wednesday, my lord.
Wednesday.
Yes.
Wednesday. In the meantime, the learned additional public prosecutor shall produce the case diary. Since the petitioner is already protected by an interim order by the learned sessions court,
Yes.
by the learned sessions court in that case, this court has not passed any interim order today, same will be considered on Wednesday.
Witness.
Would you play or not?
Have a seat.
all time.
No, you can have it, that will return it.
I'll approach it.
That's why I fixed it after completion of all this.
I always